Good evening and welcome to the May 16th, 2023 Board of Adjustment meeting. Due to the number of items submitted this week, I would like to propose splitting the agenda into two meetings. In order to do that, we need to vote on the postponements. So that's what we're going to do. We're going to take them one by one, okay? It will not take very long.
You need a motion to take it out of order.
Okay, sorry. Thank you.
They can't hear you, so.
They can't hear me? No one has ever told me I'm quiet. I will try. Okay, so I need a motion to take this out of order, please.
So moved.
Is there a second?
Second.
All in favor?
Aye.
Okay, thank you. So the first item that has been postponed for next week is the request of Angela Davis and Catherine Nolte for property located at 276 Aldrich Road. Is there a motion?
So moved.
To postpone to May 23rd. Second?
Second.
Okay, all in favor?
Aye.
The next item is the request of Peter Gamble, owner for property located at 170 Aldrich Road.
I think we just postponed
I know, we did. I'm sorry, didn't have a line there. Sorry, people, that's not posted. I have to do it again. Okay, can we unpostpone that last item?
So leave Angela Davis on.
Yes.
Okay. I move to reinstate the Angela Davis, Catherine Nolte matter for 276 Aldrich Road.
Okay, thank you. Is there a second?
Second.
All in favor?
Aye.
Okay, sorry.
Madam Chair, can we have a discussion on that motion?
Yes?
Okay. I guess I'm still unclear why we have to postpone all of these cases. We've never done that in the past.
Yes, I was asked to do this evening.
I can explain that. Recently, the paper changed their deadlines for noticing, which caused a little bit of a backup in our office. So we weren't able to notice for the second meeting right off the bat. So all of these were noticed for the first meeting. And because they were noticed for the first meeting, we now need to go through and postpone them one by one for the second meeting.
Okay, but we intend to get this straightened out for the
Yes.
month of
Yes,
June?
we have not done this before, and we won't.
Okay, this is the second month in a row that we've had to do this, so just,
Yep.
okay, thank you.
Okay, I'll do this one.
Do that. No, the D is what we do.
The request of Sean Bardang and Michio Bardang, owner for property located at 39 Dearborn Street, to be postponed till,
Make a motion?
is there a second?
Second.
All in favor?
Aye.
Aye.
The request of Thomas Rooney, owner for property located at 29 Spring Street, to be postponed to the May 23rd meeting.
So moved.
Is there a second?
Second.
Okay, all in favor?
Aye.
Okay. I don't think I did the first one, did I? No. The request of Peter Gamble for property located at 170 Aldridge Road. Is there a
So moved.
Postponement? So moved.
postponement for May 23rd? Motion, second? Yes? All in favor?
Aye.
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 Come on. The next item to be postponed is the request of Scott Day and Marta Day for property located at 18 Walden Street to May 23rd.
So moved.
Thank you. A second?
Second.
Thank you. All in favor?
Aye.
The request of the Islamic Society of the Seacoast Area, ISSA, owner in Schindberg Development for property located at 686 Maplewood Avenue, to be postponed till May 23rd.
I'll recuse myself.
Okay, thank you. Is there a motion?
Second. So moved.
It has to be moved. He only recused himself.
So moved.
Is there a second?
Second.
Okay, thank you. All in favor?
Aye.
Okay. The request of Carol Krukoff, owner for property located at 3360 Lafayette Road, should be postponed until the May 23rd meeting. Is there a motion?
So moved.
Second?
Second.
Okay, all in favor?
Aye.
Thank you.
Aye.
The request of John Heath and Michael Meserve for property located at 955 Woodbury Avenue to be postponed to the meeting of May 23rd. Is there a motion?
So moved.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The request of Shantar Zudima and Abby Zudima for property located at 126 Burkett Street to be postponed to the May 23rd meeting.
So moved.
Thank you. Is there a second?
Second.
Thank you. All in favor?
Aye.
Okay.
We have accomplished our task. Okay. So, I'm just going to remind everybody that the presentations are 15 minutes each. If you think you're going to run over, please ask us ahead of time, and the board will vote on it. If, for people who are speaking to any of the items, public comment is 5 minutes. Okay. Approval of the April 18th, 2023 minutes.
So moved.
Is there a second?
Second.
Okay, any discussion? Yes. I'm sorry, I have them out here.
Two things. On page 16, there's a statement that the property in the middle of the page, and I can tell you where, is 40 acres, and I know that property is not 40 acres. And then on page 17, I think I said comply with the law, not comply with a lot.
Probably.
And that's it.
Mr. Ram, did you have a change?
Yes, I have a couple of corrections. On page 13, the paragraph under discussion of the board, fourth sentence, currently reads, he said future property owners' hands would be tied in developing the property. I really don't think that captured the essence of what I was trying to say, so I would like to think it should instead read, he said that a stipulation requiring this would unduly restrict future property owners, period. So get rid of the hands would be tied in developing the property and add in that other sentence. Also, the next would be a sentence, which could be a source of a possible lawsuit against the city, should be part of that sentence. Pardon me. And then the next sentence, it really doesn't, again, capture anything that I was saying in my opinion. So I would strike that sentence. And then further down, the last full paragraph on that page starts out, Mr. Rayom concurred. About the middle of that paragraph, he said the 100-foot frontage requirement had not stuck out since 1942. Just to clarify that, he said that the 100-foot frontage requirement, add in not being met, had not stuck out since 1942, because basically that had been in place since that point in time when the house was built. That's all I have. Thank you.
Okay. Anybody else? Okay, is there now a motion to accept the minutes with these amendments?
So moved.
Okay, is there a second?
Second.
Okay, all in favor?
Aye.
Okay. Now to the minutes of May 2nd, 2023. Well, I guess we should discuss first. Are there any amendments to these minutes? Any suggested changes? Okay. Then is there a motion to approve?
So moved. Second.
Thank you. All in favor?
Aye.
Okay.
Abstain.
Yes. Okay, the first item of business is the request of 635 Sagamore Development LLC owner for property located at 635 Sagamore Avenue, whereas relief is needed to remove existing structures and construct 4 single-family dwellings, which requires the following. 1, a variance from section 10.5 to allow 4 freestanding dwellings where 1 is permitted. 2, a variance from section 10.521 to allow a lot area dwelling unit of 198 square feet per dwelling where 43,560 square feet is required. Said property is located on Assessor Map 222, Lot 19, and lies within the Single Residence A District. And as you can see, David Rayom and Tom Rossi have recused themselves from this petition.
Yes, thank you, Madam Chairman, members of the board. I'm Tim Phoenix from Hopeful Phoenix, Gormley and Roberts. I'm here tonight on behalf of the owner and applicant. With me is Mike Garapi, who is also the owner's representative. We have decided to go forward with only 6 members. We have continued this a couple of times. I think one we only had 5, and then last month I was hoping against hope that we could get somehow 7 members, but it looks like that's way off, so we've decided to go forward. I think I can get by through this in 15, but I would like to go to 20 if anything gets bogged down by me.
Do we need to vote on that, or just agree?
I think it would be safe to vote on that.
Okay.
And just to clarify, are ML and Jody seated?
Yes, you are seated on this, yes, both of you, because we need you. So we're going to take a vote on allowing the extra 5 minutes. Is there a motion?
So moved.
Second?
Second.
All in favor?
Aye.
Thank you all very much.
Good to go.
Okay, so thank you, Stephanie. The lot 635 Sagamore is up on the board here. This is the existing conditions. You're probably all familiar with it and have driven by it hundreds, if not more times. It's the what we call the Lester King lot, where on the front of the lot, partly in the setback, is the old Lester King car detailing business with an apartment that the Lester King owner resided in for many years and still does, I believe. Out back is an auto repair place. There's about 150 feet of frontage, and there's no curbing. You're able to access or leave the property anywhere along that 100 feet of frontage. Where you can see the back building here, that is a roughly elevation 70 to 72. At the bottom, where it abuts the Tidewatch roadway, it's around 38 or 40. So there's a 30-foot increase from the street at Tidewatch up to the top. If you can go to so here's what's planned. 4 units, and the back of those units is at about elevation 60. So it's about a 20 to 25 foot rise in height from the Tidewatch to the back of those buildings. The lot itself is 84,795 square feet. I think anyone who has been by that lot anytime recently would agree that it's essentially an eyesore. It hasn't been dealt with in many, many years. The current uses do not meet zoning for the SRB district. If you drive out there today, you'll often see cars in need of repair that are sitting partly done and partly not done. If you go out back, there's pallets and all kinds of other stuff strewn out there. So I think anyone would agree that it at least makes sense to look at trading that old unsightly land and buildings for new condominium form of ownership, single-family homes, as is outlined here. We started this process about a year ago, and at that time we had proposed 5 units. We were contacted by counsel for the board of directors, and through a number of negotiations and site walks with them, we agreed to reduce it to 4 units. And as you can see, the ring around the units, the dark ring, that's a fairly heavy landscaped buffer. The area of the lot below that will be left as it is, which is a wooded lot, a lot of pines and what have you. The point of my telling you about the elevations is that, at least in my opinion, the large majority of the Tidewatch residents, several of whom, if not more, are here and have expressed opposition to the project. You have to really kind of look for it. If you're driving out the Tidewatch Road and you're looking at the road, you don't see it because it's way up here. Most of the residents don't see it from their homes. The only time they would see it is if they're driving in and out. There are several of the first units, I don't know how many, maybe a handful, maybe a few more. Their front doors, face this. We are frankly puzzled that they would prefer to have something stay that's there like there now, rather than what we're proposing. So, if you look at the project, which will require planning board approval, if you look at the project as you're driving in and out of Tidewatch, you have to tilt your head up to see it, and you're going to see it through woods and through all these plantings that we have proposed. I'd also like to mention, if you can go to Exhibit E, Steph. There's the photos. One more there. So you can see our lot is outlined in blue. The tan area is the SRA district that we're in. Across the street is the SRB district. SRA has 1 acre per unit. That's what zone we're in. It's a very, very small zone. SRB has 15,000 square feet per unit. And the garden apartment is the orange look, and that's where the Sagamore Court is. To give you an idea of the numbers, SRB, as I said, requires 15,000 square foot per unit. Fairly recently, we all know the Golden Egg restaurant, which closed, and now they've been made into apartment units. That is 6 units on 43,996 square feet, or 7,332 square feet per unit. If we were across the street, we would meet the zoning requirement. We are on 84,811 square feet, or 1.947 acres, and we have 4 units, which is 21,203 square feet per unit. Tidewatch, which is, you can see the units behind our, is in the same zone. It's 53.59 acres, or 2,334,380 square feet, with, I believe, 122 units, which is 19,134 square feet per unit. So our density is better than Tidewatch. Next to Tidewatch is the Sagamore Court. That requires 10,000 square feet per unit. That's on 15.01 acres, or 653,836 square feet. There's 144 units, so that's about 4,550 square feet per unit. So we fit in very well, and in fact favorably in terms of the density compared to everything that's around us. I consider this sort of I think, in my opinion, it's improperly zoned because the large majority of the lots in it don't meet the requirement. But to look at the purposes of the SRB and SRA district in the zoning ordinance is to provide for single-family dwellings at low to medium densities, approximately 1 to 3 dwelling units per acre, and appropriate accessory uses. So we've got 4 units on just under 2 acres, so we do meet that overall purpose. The point of all of that is that while we're asking for the this relief, we are favorably compared to other uses, notably Tidewatch, which is right next to us. I'm going to go a little out of order and talk about the effect on property values. You have a letter that was submitted by a single Tidewatch resident, James Lalos. I hope you read that because I think it's very well reasoned. We've also provided an appraisal from Brian White, a longtime real estate appraiser, and I'm going to read his final paragraph of his appraisal. It is my opinion that granting this requested variance for the subject property to be improved with a 4-unit freestanding single-family development will not result in the diminution in value of abutting property values in the immediate vicinity of the subject property, and that the proposed subject property would not change the characteristics of the neighborhood. In fact, the addition of the proposed subject property will add several attractive and modern single-family residences to the neighborhood that very well could enhance the value of surrounding properties, as it will add new residential units to a location that is currently under-improved for the area. And I think that kind of sums up what we're trying to accomplish here in a nutshell. So, going faster than I thought. Going through the Gordon Egg, let's see. So I summed up in my submission, in addition to cleaning up a long distressed and non-conforming site, including narrowing the current open frontage, I don't know if I mentioned that, but there will be a single in and out, which will be addressed by the planning board as to the proper location, given the roadway we all know, and we're going to hear about that there's a hill there and people come over the hill. But we have the right to utilize the property, and this is a good use of the property that is likely to be less intensive on a day-to-day basis than the commercial uses that are there now or might be there in the future. In addition to cleaning up a long distressed and non-conforming site, including narrowing the current open frontage curb cut, the proposal creates a natural transition between the SRB zone across Sagamore, the existing multi-building condominium developments to the north and west and to the rear, Tidewatch, and the nearby single-family homes. So turning to the relief we need, the first two were always considered together. I cite the Malachi Glen case and others, and those are that the variances are not contrary to the public interest and the spirit of the ordinance is observed. I go through the purposes of the zoning ordinance in my submission. I won't go through that now, but the bottom line is that the case law says that in considering these two, we ask whether the variances will alter the essential character of the locality or threaten the public health, safety, or welfare. These units compare favorably in size and design to Tidewatch and to, if you will, the Golden Egg apartment building. It's not the same style, but it's relatively modern. It fits in. It certainly fits in better than what's there today and has been there for decades. So the essential character of the locality, if it's changed at all, is going to be a positive. We're asking for this board to consider that it doesn't make sense to require one house, which would be a very large house on this lot, when everything around it is in the same boat, meaning that none of them meet the current requirement of an acre per unit. Similarly, the buildings that are there now are old and worn out, so we're going to have 4 brand-new, 2 code-compliant units, so it's not going to threaten the public health, safety, or welfare. The third test is that granting the variance will not diminish surrounding property values. We have an expert opinion on that. I think it makes common sense that replacing those old buildings, the Lester King building and the auto repair shop building out back, and cleaning up the site, taking out the sea of pavement, the old cars and those kinds of things is going to be a plus for surrounding property values. The fourth test is the unnecessary hardship. That's 3 prongs. Special conditions distinguish the property from others in the area. Again, we are nestled in an SRA district where it really doesn't really apply to anyone who's in it. Across the street from an SRB district, which has lower density, and next to the apartment district, which has lower densities yet. The size, shape, and location of this lot and the uses that are around it and the density of those uses distinguish us from other properties in the general area. We are similar to those that touch us, but in the general area, we fit in very, very well. I'd also like to mention a case I cited, which is Walker v. City of Manchester, which provides that a hardship can be found where similar non-conforming uses exist within the neighborhood and the proposed use will have no adverse effect on the neighborhood. That applies specifically here. As I've mentioned ad nauseum now, the uses around us don't meet the requirement for density as it is, so we are fitting in with that use, and it's certainly going to be an improvement over what's there today, so it's not going to injure the neighborhood. The second prong is that there's no fair and substantial relationship between the purposes of the ordinance and its application in this instance. I've already read to you the purpose of the SRB and SRA district. We fall in with that purpose. We don't meet the letter of the number of the 43,560 square feet per unit, but in terms of the reason we have it and the reason it shouldn't apply here is because we fit in well with the neighborhood. As I put in my submission, the transitional location located near and adjoining 2 densely developed condominiums and across Sagamore Avenue from the SRB zone is well suited for the proposed 4-building single-family development. The third prong is that the proposed use is reasonable. It's a permitted use, meaning residential, so the use itself is reasonable. And finally, substantial justice. And as I always do, I cite the case, the Harborside case. If there's no benefit to the public that would outweigh the hardship to the applicant, this factor is satisfied. Any loss to the applicant not outweighed by a gain to the general public is an injustice. So this requires you folks on the board to do a balancing test against private rights versus the effect on the public. And we submit that the location of these buildings, tucked, if you will, up the top and over the top of the hill, combined with a single way in and out, which is going to be better for safety, less traffic than commercial uses, and replacement of those old worn-out buildings that I've deemed an eyesore, is no harm, causes no harm to the public, while denial will deny the applicant and owner the right to have a project that is financially feasible for them and also fits in with the neighborhood in terms of density. Did I make it in 15?
You did, you're good.
I'm going to turn to Mike Garapi here and see if there's anything he wants to add before I Okay. So if you have questions of me, fine. I would like to, the ability to, what I anticipate is going to be rebut comments of others.
We do have questions
Okay.
for you now. Go ahead.
Thank you, Attorney Phoenix. So I think, I'm sorry, did I jump in?
No, go ahead. You're good.
Okay, sorry. I apologize. So initially, I agreed with you in that I thought that this property was sort of wrongly zoned. However, I don't think there really is any other zone that the city could apply to it other than single residence A, because it is, although it is over an acre, it's certainly not 5 acres, which would be the rural designation. And the apartment complex next door is general apartment, and also manufactured homes. And Tidewatch itself is single residence A, but it's a planned unit development. It has over 50 acres. So I think given that, why do you think that it may be improperly zoned?
Because even though it's a planned unit development, in terms of the requirements for density, we wouldn't meet this density. They don't meet that density. The apartment buildings next door don't meet the density. And the Golden Egg property that was just recently approved doesn't meet the density requirements of SRA. And I don't have numbers on this, but I would dare say that many of the few homes that are along there are not on 1 acre lots. So we believe that this density is fair, and remembering that we've reduced it from 5 to 4 after negotiating with the Board of Directors, who withdrew their objection last year after we reduced it to the 4. That's our position.
I have just 2 follow-ups. So I did a little bit of searching, and it seems that 576 Sagamore is 1.7 acres and 650 Sagamore is 1.51 acres. However, they are zoned SRB, which is a little anomalous since they are also well over an acre. The other question I have for you is Walker versus City of Manchester. When there's other non-conforming uses. As I read that case, it meant that I thought it stood for the fact that if the non-conforming uses are created by variances. Is that what your understanding of the case is?
The quote, if you will, I cite here is hardship may be found where similar non-conforming uses exist within the neighborhood, and the proposed use will have no adverse effect on the neighborhood. I don't recall off the top of my head that this was drafted quite some time ago now, so I haven't read the case in a little while. But I don't know that it matters whether or not, I think in that case, there were other funeral homes, I think,
Yes,
that have been
variances for funeral homes.
had been permitted. But I think that the point is that if you fit in with the neighborhood you're in, and because everybody else doesn't really fit in for whatever the reason, that demonstrates a hardship. That's how I interpret it. I don't think it was just lots that got variances.
Okay.
But I think I interpret that case as we're trying to get a variance, so they were relating it to the uses in the zone that also got variances.
Okay, so, and that would be your main hardship argument, that there are other non-conforming uses?
Well, I think it's whatever you guys are convinced by is my main argument. So it's a twofold. That's a pretty good case and can apply in a lot of variance requests these days. But also, I think that the nature of this lot, where it is in an SRB zone, where nobody complies with density requirements, its size, its shape, its location, all also contribute to the hardship.
Thank you.
Paul had his hand raised for a
Sorry.
question.
Thank you. So in your opening, Tim, these are all going to be condos.
Condominium form of
Single-
ownership. Yeah, single family.
Okay,
but
so there'll be an
stand-
HOA.
There will be a condominium association.
Okay. So it will not be a planned unit development, correct?
Correct.
Yeah.
So you'll still have to go in front of the planning board and TAC
Yes,
for final approvals, correct?
correct.
Okay, thank you.
Are there other questions at this point?
Okay, thank you.
You're welcome. Is there anyone to speak in favor of this project? Is there anyone to speak in favor? Is there anyone to speak in opposition to this project? I will let you sort yourselves out, but don't crowd at the mic.
All right.
Is there an extra copy of that for us?
I believe so.
Yeah, there's a couple folks that didn't recuse. Happy to have you have it. Check that. I don't have approval from people with their contact information there, so once I get that, I'm happy to share it if people say go. All right? All right, I don't want to lose my time here. My name is Tim McNamara. I live at 579 Sagamore Ave, Unit 19. First, personally, I appreciate the board's patience with me in the January meeting when I spoke out of turn. Based on the importance of this issue, we at Tidewatch formed a small committee to represent our neighbors who have given me the opportunity to speak on behalf of those unable to make it here tonight. While we recognize there are times that granting variances make great sense, we do not believe this is one of those times. Since the December Tidewatch annual meeting, the community has been universally opposed to the project, as Tim pointed out, with the exception of one who supports the idea, and a couple folks who abstained. With this petition in front of you from December of 2022, and subsequent emails that are copied there as well, over 90% of the community, and not just Tidewatch, but other neighbors, are opposing the position. Portsmouth residents oppose the current project and request the ordinance be followed as written: 1 house per acre, 1 dwelling per lot. As you are all aware, this process is approaching a year from the initial proposal. Recently, the new current investor of the and property owner requested a continuance to deal with the abutters' concerns. A representative committee of our neighbors, of which I'm one of, along with other Sagamore neighbors, attended that meeting with Tim Phoenix and Mike Garapay both. The investor did not show up. While the meeting was intended to assuage our concerns, quite the opposite happened. After the planning consultant clearly identified the tree cut line, the position of the houses based on stakes he pointed out, and the fact that significant amounts of ledge would have to be blasted and removed, we became considerably more concerned. If you look at map C3 in your packet, and I believe it's, thank you, that's the one up there, the elevation that Attorney Phoenix mentioned is really considerable, and if you go down the little bit of a curve on our road, it's even higher than what Tim mentioned. But I appreciate the fact that he mentioned 20 to 30 feet, because that's what was in my document as well. So that's the foot of the building, and then there's a 30-foot house on top of it. And importantly, and one of my neighbors will speak more completely to it, if you look at the compass and you look at due north, the sun will be coming up over those houses, and our community and the neighboring houses will be, or a couple neighboring houses, will be blocked out of light and space, not to mention the potential drainage issues that will be caused by the blasting. Finally, all the points of the letter of public record of She and Feeney dated April 18th are still valid. How can a new owner investor claim unnecessary hardship when they know the property size and the ordinance that's in place currently? The proposed cluster development offends the spirit of the ordinance and therefore negatively affects public interest. Consider traffic safety, alteration of natural space, and density. Nearly all the abutters see no justice being done by granting a variance. And while the investor had an appraiser submit some comparative data regarding property values, we do not believe it represents the impact on Tidewatch neighbors. It may have a different impact for other neighbors on Sagamore. So thank you for your consideration, and we look forward to a decision.
Okay, thank you. Next person who would like to speak?
I'm Ann Hartman, and I live in Unit 3 at Tidewatch. The 4 proposed buildings will have a profound impact on the entire Tidewatch community in terms of height, light, and drainage. The effect will be particularly harsh on the part of the community that's closest to Sagamore Avenue and the Tidewatch entrance. In terms of height, the proposed buildings are 30 feet tall. The buildings will sit on ledge that's about 22 feet above the street. So 22 plus 30 is 52. But in addition, we need to add another 6 to 8 feet because the first 7 units in Tidewatch sit at the base of driveways that slope below the level of the street. Effectively, the buildings from that vantage will appear 60 feet tall. The side wall of the proposed buildings will face the first 7 units directly, and when combined with the proposed reduction in side setbacks and the extensive number of trees slated to be cut to accommodate them, the buildings will be an inescapable looming presence. The excessive height issue is tied directly to our concerns about light. We fear both a reduction in natural light and at the same time a potential increase in outdoor lighting. All Tidewatch units have one first floor kitchen window facing the street. It is the only front-facing first floor window, the only one. In the case of units 1 through 7, that window faces east. Therefore, it provides sun and light until about midday. 2 of the proposed buildings will be directly outside those first floor windows. Should the proposed buildings be allowed, that sunlight will be blocked behind 60 effective feet of building. Moving to a slightly different light aspect, the proposed buildings will require outdoor lighting and street lighting. Again, given the height of the buildings and the shrunken tree cover, we have reservations about artificial light penetration at night. But drainage is perhaps the most serious of our concerns. It's an ongoing challenge all around Tidewatch, but nowhere more so than near the entrance. During storms, water runs freely down from Sagamore Avenue and from the proposed building site, both of which operate higher ground, and as we all know, water seeks lower ground. Many attempts over the years have tried and failed to find a reliable remedy. In just the last few years alone, a new drain was installed between units 3 and 4, an entirely new driveway at unit 5, all in attempts to control the drainage. Further, a new and very large drain was installed at unit 1 last fall, and and the entire driveway between units 1 and 2 was excavated, regraded, and reconstructed just last month. Significant dollars have been spent removing the permeable surface of the Luster King property, crowding that higher ground with houses, their garages and patios, as well as a roadway and a turnaround, will make our current drainage struggles into an even bigger nightmare. For all of these reasons, we ask that you carefully consider the serious long-term impact of this project on its immediate neighbors, their property, and the community in general. Thank you.
I just want to say one thing. It is not that we don't care about water, it's just not our purview. This has to go to Technical Advisory Committee.
Okay.
So, just so you know.
All right.
Good evening, Madam Chairman, board members. My name is Jerry Stowe, and I live in Tidewatch at number 22. The initial presenter this evening talked a lot about density requirements, and I'd just like to, for the record, straighten it out. As a 10-year board member in Tidewatch and 3 years as the immediate past president, I can enlighten you. We do not have 122 units. We have 117 units. I don't know why the 5 were never built, but we don't have them. Those 117 units are housed in 44 buildings on 53 plus acres. So I don't do all the math, but it tells me that we do, per building, have more than 1 acre, 1 acre per building within the Tidewatch community. We do have 2 additional buildings. One is a small mailroom, and the other is a maintenance building, and that's it, but the others are all residential buildings. So for that reason, I just wanted to get that record for this straightened out for the record. And I would just like to say I agree with everything I've heard from the other members of my community, and appreciate your time this evening. Thank you.
Thank you. Is there anyone else to speak in opposition to this petition?
Good evening. My name is Hal Kale. I'm a resident at 122 Tidewatch. And my wife and I, about 20 years ago, appeared before the same board seeking a variance. And the variance we were requesting was to extend, when the units were built, there was a 50-foot setback from the creek. We were expanding the building and would now encroach on that 100, they changed it to 100 feet. So the addition would encroach upon that by 1 foot. So we appeared here, and not having an attorney, we were torn down. We then hired an attorney, spent $11,500, and hired Bernie Pellick to represent us. And God rest his soul. He appeared before you guys, laid a piece of paper on the ground, and said to the board, this is what we're looking for. It was 1 foot out of 99 feet. What they're looking for is not 1 foot out of 99 foot. They're looking for 75% out of 100%. I implore you to abide by the zoning laws. 1 unit per acre. That's all I'm asking. If they want to go and change the zoning laws, that's up to them.
Thank you. Anybody else in opposition, speak in opposition to this petition?
We have a couple people online.
Okay, we can go to them.
Peter Whistle, you have 5 minutes to speak if you want to unmute yourself.
Okay, thank you. My name is Peter Whistle. I'm a resident of Tidewatch, Unit 75. And although I'm a resident and oppose the request for a variance along with many of my fellow residents, my primary objection tonight is as an avid cyclist. In my view, the granting of the variance would be contrary to the public interest as it is a threat to public safety. As discussed at a meeting of the Parking and Traffic Safety Committee on November 3rd, Sagamore Avenue is a popular route for cyclists riding along the seacoast and the Newcastle Loop. The crest of the ridge just beyond 635 Sagamore Avenue is a particularly hazardous area as drivers in either direction cannot see beyond the crest of the ridge. The shoulder of the southbound lane is only about 12 inches wide and bounded by a curb. An impatient motorist attempting to pass a southbound cyclist must often infringe on the northbound lane to provide the 3 feet of clearance between the motor vehicle and the cyclist as required under New Hampshire law, or more likely move closer than 3 feet. This problem is especially acute when motorists nose out onto Sagamore Avenue from 635 Sagamore Avenue to observe oncoming traffic, which further limits the margin of safety for a cyclist. Having 4 units makes the risk 4 times greater than a single unit. It is not just a matter of the number of vehicles belonging to the unit holders. You also have to consider delivery vehicles for FedEx, UPS, the post office, Amazon, and service vehicles and landscaping equipment. Therefore, I think this request for a variance should be denied. I urge the committee at the very least to consult with the Parking and Traffic Safety Committee before ruling on the request for a variance. They appreciate the threat to public safety that would result from approving this request for variance. And as long as the Luster King developer mentioned it, the current owner of Luster King, the traffic generated by his business was minimal. There was the flow of traffic was very light, and quite frankly, the frontage of that unit provides a margin of safety for cyclists currently. There's no curb at all, and it's a huge paved apron which allows a cyclist an extra margin of safety when cars are trying to pass them along that dangerous section of Sagamore Avenue. So I just repeat, in the interest of public safety alone, I think this request for a variance needs to be denied. Thank you.
Thank you.
We also have Ann Walsh. Ann, if you would like to unmute yourself.
Thank you. Can you hear me?
Yep.
Yes.
Hi, my name is Ann Walsh. I'm the co-trustee of Unit 7 of my mom's unit. And I strongly and respectfully ask you to deny this variance because it doesn't meet the variance criteria nor all of the special exemption standards. I'm going to focus on density because that is one of the things that we talked about this evening, because essentially this proposal is creating a gateway neighborhood, which by definition alone encourages walkable mixed-use development and intended to be located in more dense areas, which include business to walk to support, go grab a cup of coffee, buy from a local shop. Those zones are near Lafayette. We're in a residential district, and we can't walk across the Sagamore Singing Bridge anymore to go to the Golden Egg, which I do want to point out is on the other side of Sagamore. There's no place for that. And so it doesn't really fit into this area, and I believe is contrary to the Gateway Ordinance purpose. And I would argue that it would change the character of this residential district by allowing a gateway community and would be in violation of special exemptions and variance criteria. It also would be a very dangerous precedent for the other surrounding properties, so it doesn't satisfy the spirit of the ordinance. I believe that it would be changing it, because down the road in time, the same developer or other developers will come in and easily gobble up properties and then overdevelop them because of this precedent, and all in the name of profit instead of intentional planning. And what would that overdevelopment do to the wetlands? And what was the original spirit of the ordinance on this side of Sagamore? Was it to have less developed parcels since we're so close to the large wetlands? For all the reasons mentioned, I believe it's contrary to public interest and the spirit of the ordinance and the zoning ordinance and planning of the city of Portsmouth. In their proposal, I believe, just as Jerry Stowe had pointed out, that the density requirements have been met, not only by Tidewatch but also Sagamore Court. So we have 1.22 acres per building in Tidewatch, and the Sagamore Court has 144 apartments in 6 buildings, which is 2.5 acres for each. Both Tidewatch and Sagamore Court, they respected the wetlands in their planning, their development, and observed the density requirements, which is why my family bought a unit over close to 34 years ago. So to be clear, their proposal would be more dense at 1 building per half acre, unlike the surrounding properties. I don't believe it would grant substantial justice. I believe that it would be unjust to the Tidewatch community. We currently stare at a tall hill of woods and wildlife and granite. It completely fits into the character of our community that was intentionally planned. If the proposal goes through, it will change that characteristic of our neighborhood, impact the wildlife, and it will tower over us and absolutely impact our appraisal values. We will have increased noise and increased lighting. The appraisal didn't address noise from the backyards, the patios, the decks. Businesses don't have parties, houses do, and also stormwater runoff is a concern and is also one of the exceptions that has to be cleared in order to be accepted. So the property is paved on the top part, and it will be developing more of the parcel and paving on the hill, which will alter the stormwater run and run right down into our community and the wetlands. So I don't believe these points satisfy 2 of the special exemptions. I would also go further to say that I'm not sure how they can claim hardship when they knew it was zoned for residential when they bought it for approximately $300,000 under the appraisal. It seems like they're ahead of the game at this point. They're rolling the die and hoping to get a variance, make as much profit as possible without living with the consequences of this decision. We would. Again, it would be unjust, especially to the Tidewatch community. And they will need to blast a lot of granite to build the homes, and so there's major concerns specifically on our foundations. So I do not believe that a Gatewood neighborhood has any purpose here, and again, would be a very dangerous precedent and drastically change this district. The special exemption standards and variance criteria have all not been met, so therefore I respectfully ask you to deny this proposal. Thank you.
Thank you. Is there anyone else online?
Nobody else online.
Okay.
Good evening. My name's Het Swoholtz. I live with my wife in Unit 69 in Tidewatch. A lot of people could not be here tonight. A lot of people wanted to be here, but I think it's important to make a statement to show the number of people from Tidewatch that are here tonight. So if you could raise your hand from Tidewatch. I think you see the interest we have in this project, and once again, we would like you to not approve this project. Thank you.
Thank you. Is there anyone else to speak in opposition? Anyone else to speak to, for, or against?
Thank you, Madam Chair, members of the board. First of all, I'll be fairly brief here. I would like to say how much as a practitioner that I have appreciated the professional way in which the Tidewatch neighbors have approached this. In particular, Tim McNamara, with whom I've had a fair amount of communication. It's all been very professional and polite. You don't always see that, so it is appreciated. Turning to the comments, most of which I've addressed, I just ask the board to consider what I mentioned at the outset, which is you have to look for these buildings. You have to look up, and if you're driving, look off to the side to see these buildings. It's through a wooded area that's already there. We don't need any height variances, so whether there was one gigantic house or even an expanded or a moved commercial use on that building, you're going to have the same issues. I understand the issue about the sun and air and light, but I really don't believe that is going to be any negative effect on them, at least not from very much, after the morning. You can see north is pointing down to the left, so east would be up to the right. I just don't think that's an issue much more than the buildings that are there today. These are going to be 30 feet tall. I think we haven't measured, but I'd say the buildings that are there are 25 feet tall-ish. So there's not much difference. And I respect the concerns about things like ledge and drainage, but as the chair pointed out, not zoning board issues. We will have to go to the planning board, which will vet this project, as will the Technical Advisory Committee, which, for those who don't know, is made up of the various department heads, fire department, Public Works Department, planning, et cetera. So everybody looks at this very, very carefully. And the rule or the law is that we can't increase runoff from our site post-construction compared to pre-construction. And we think that it's going to be much better than it is now, because right now there's a whole lot of pavement there that water just hits it and runs down onto Sagamore Road. I'm a cyclist myself. I respect the concerns expressed, but I don't think it's fair to saddle this applicant and 4 homes with that concern. There are things that can be done traffic-wise, but the major change is that, as I mentioned, we have 150-foot-ish open curb cut now. That is going to be narrowed to probably 22 or 24 feet. I think people who are around here or live there are aware of the issues with not only cyclists but cars coming over the hill. I disagree with the statement that somebody made that 4 homes is going to be more intensive than Lester King. It's not very intensive at the moment, but the Lester King owners live there, so there's one household full. I've been on the site when there's been numerous cars come in and out of the car repair place. Things like traffic safety, tree cutting, drainage, all those kinds of things are going to be dealt with at the planning board level. And just to clarify, I'm not sure I fully understood Ms. Walsh, but she was talking about a gateway district. That's kind of next door, and it's not where we are. But I asked the board to come back to the density, which is what I'm calling density is the number of units, and it just seems to me incongruous to allow more units per square foot at Tidewatch, and then it's not fair to have us have even more square footage per unit by several thousand square feet. I don't. Whether it was 117 units. Whether it's 117, I got 122 units, but if you drive into Tidewatch, it actually looks, because it's a planned unit development, it looks more dense than it is on an overall basis, because all the homes are fairly close together to create the planned unit development in the open area. And as for property values, we've got a long experienced expert appraiser who's opined. There's no counter to that here, so I think it carries great weight. And we hope that you will see that fairness dictates that while the concerns of the Tidewatch residents are understood, I think that they're not as significant as they think they're going to be. A home could be put where any of these homes are. If somebody wanted to put one very, very large home there, trees could be cut for commercial uses, for anything. That's not the intention. The intention is to cut only as is necessary to put these buildings up and provide, as I mentioned at the outset, a very significant buffer. It's going to take some time to grow up, but you're looking through trees already, and you're going to have a strong landscape buffer behind those houses. That's all I have to say, unless you have questions.
Questions?
Madam Chair?
Yes.
We do have Peter Whistle online that would like to speak again. He's raised his hand. Are you allowing second-time speakers?
If he has something new to say. All right.
We'll see if he does.
No, I just heard that my statement was misinterpreted. I didn't mean to say that the amount of traffic from the proposed development would be 4 times what it is at Lester King. I have no idea how much more or less the volume of traffic would be. My point was that 4 units would generate 4 times the traffic of 1 unit. And I don't think that's really disputable. I mean, if you have 4 units, each with probably 2 cars, as opposed to 1 unit with 2 cars, plus all the delivery vehicles and everything else, it's going to be 4 times the volume that 1 unit would be, which is what it's currently zoned for. Thank you.
Just one technical item, Madam Chair. Mr. McNamara, people with him handed out something to you. I have no idea what that is. I don't know if I can. Are you okay with me seeing it? It seems to me once it's been turned in, it's a public record.
Mr. McNamara was going to check to see if people minded giving this information out.
Right. And may I just address Tim's question?
You may.
Come on up.
The document.
Tim, can you come to the microphone, please?
I raised 5 kids. I didn't really need a mic. The document that I handed out was, I should have explained it greater. It was a petition signed by the significant, nearly all the neighbors. And those that did not get to do the petition, I had just hailed out to them to say, if you're opposed, send me an email. And I consolidated those emails, and they're there. And that's what I'm talking about as far as their contact information. But it was a petition and then emails, all expressing opposition, bringing nearly the whole neighborhood to the conclusion of opposition.
Thank you, Tim. The fact remains that it's been turned in, it's a public record. I should be given a copy of it, and I should have been able to see it. I don't mean any fault, because they don't know how things work here. I do. It would have been nice to have it so I could, make a comment if I wanted to, so.
You may.
And then the only other thing, and then I will promise I will sit down and stop talking, is that just consider the fact that we are improving a nonconformity. We are going to residential use, which improves the nonconformity of the commercial use presently on the site.
Okay, thank you. Here. I know someone will give me another one.
Thank you.
You're welcome. Is there anyone to speak to, for, or against this proposal?
Can I ask a question of the? One thing
You
that I
can
have.
only ask questions to us.
Pardon?
You can only ask questions of us.
Oh, okay. Do we know the site distance from the entrance there to the crest of the hill?
I bet we do, but hold on. If you do know that, you may answer for us, or tell us, and we will answer.
I
Do you know?
walked it. Yeah, I would say that driveway is maybe 20 feet from the crest of the hill, roughly. 20 to 40 feet. It's very close to the crest of the hill.
And second question, is this going to be a city road or is this a private road?
I assume it's a private
Private
road. It's a
road.
private development.
Says-
You have a private road. This is
Yeah.
a private road.
So is the requirement for a private road just different than a city road?
I don't know the details of that, but also it would be up to TAC.
Okay, thank you.
Hi, I'm Susan Von Hemmert, and I live at Tidewatch number 42. I appreciate all my neighbors speaking up. One thing that I think when we talk about the density, what hasn't really been made clear is how many trees are going to be cut down. Those are 30, 40, maybe 50-foot pine trees that are up on the crest of the hill, and those would essentially, by this development, be totally wiped out. Now, as we talked about the runoff coming into Tidewatch, I think there would also be significant runoff going into Sagamore Creek as well, which I think is a concern, because you're taking previously pervious surface, turning it into impervious surface, and now we do have impact to wildlife. We have deer, we have coyote, we have birds. All of those things would be seriously impacted by turning this all into just a barren wasteland. And you're saying you would look up through what they're proposing to plant. Those maybe would be 10 or 20-foot trees, which does not address looking up with that 60-foot building at the very top, now totally denuded of trees. So I will render my opposition to this as well. Thank you.
Thank you. Anyone to speak to, for, or against? Last call. Anyone to speak to, for, or against? No one online? Then the public hearing is closed. Anybody? Just gonna ask you again. So it's by 44, okay, that's what I said.
Sorry.
Yeah.
Yes.
Okay. Anybody?
Well, I'll open the discussion. Just thoughts. Not making a motion yet.
No, okay.
We've had this, as the abutters all know, several times before. And it's been postponed several times because of the number of members that were decided. That's his right. Looking at the project, when I first saw it, I didn't think it was feasible. Somebody mentioned earlier this evening about it would set a bad precedent. Unfortunately, the precedent has already been set. Tidewatch. Tidewatch is single residence A. According to the city records, it's 122 units on 54 acres, which makes it 19,281 square feet per unit. Clearly non-conforming with the single residence A. What Mr. Phoenix is asking for tonight is a planned unit development short of that for single-family condo units on 1.84 acres, 94 acres, 4 units, 84,790 square feet, which would make 1 unit per 21,199 square foot. So 2,000 square foot greater than Tidewatch. That's your precedent. If Tidewatch wasn't there, this wouldn't fly at all. I appreciate the drainage issues, the light, the air, so on and so forth. That is not our purview. Those are all TAC, Technical Advisory Commission. The owner could clear cut it, and you would have no say. The owner could put up a 5,000 square foot, 35 foot tall single family residence, which would do the exact same thing to your light and air, and you'd have no say. I understand the difficulty being in this position several years ago about a development across the street from my house. My issues did not stop the development. As soon as the development became a citywide issue, that stopped it, because the promises made by the developer to the committees were bogus. I just happened to point it out. This is difficult because we're balancing the needs and the opinions and everything of an entire neighborhood, I get it, with one developer. But when you bring up points about things we have no control over, or the developer is doing it for money, that's what Tidewatch did. They did it for money. If there was no Tidewatch, there'd be nothing in the neighborhood to compare this to. Absolutely nothing. And this would be totally out of place. But Tidewatch is there, and this is comparable, unfortunately. That's where I'm at right now.
So I do think this is a very difficult application. It's not eligible for a planned unit development because it's less than 10 acres. However, there are some real benefits to this application in that it is bringing the land more in conformity, the use in more in conformity with the land as a single residence A. The lot is quite large. It is definitely quite large. I think that it's in a lot of ways very much in keeping with the character of the area in terms of the Tidewash development and the garden apartments next door. That's what I see when I see this. All that said, I am struggling a little bit with the hardship, because I think that a reasonable use could probably be made of this property with one house on it, and perhaps a variance for a second house because it's just under the 2 acres. We still have the 1 dwelling unit per lot. But so that is something that I am definitely struggling with, whether or not this property really has hardship. But in terms of the density, in terms of its fitting into the neighborhood, I think that it does.
I too am struggling with the hardship. I can take all of the other points and see a way around them, you know, the light, the air, and that kind of thing. And Mr. Phoenix's comments about the property being improved on his side, but I don't see the hardship.
Anybody else?
Yeah, I guess I'll just share some thoughts. Yeah, I think if this was in the SRB district, it would be even more compelling. But I guess it sounds like the question of whether or not it's in the character, the board can kind of get on board with that. But for the hardship, there was some interesting points that Attorney Phoenix made in terms of my initial perception of hardship is that which makes the property unique from other ones. But it can also be said that if the other properties all also don't conform to the area or to the district that it's in, that can also be a hardship. So I think that is interesting. And I think, yeah, we're comparing. You know, there's been talk of a hypothetical single-family home on the property, but it's really it's a commercial property. That's what's there, and that's a non-conforming use. And then what's being proposed is 4 units, so it is a little bit more denser than the SRA district. Although our ordinance does also list SRA and SRB together, and says 1 to 3 dwellings per property or per acre. And yeah, I think the reduced curb cut for just a single driveway entrance could actually be an improvement as opposed to all of the current impervious area that's there from the commercial property.
Would anybody like to make a motion?
I'd like to say one thing.
Please.
And I want to say this. We are here to consider our zoning ordinance and the proposed use to determine whether the criteria for granting a variance have been satisfied. And it is so tempting with this particular ask to do the work of the planning board and the technical advisory committee with regard to density, location, drainage, all of that. I mean, I think I want to just be on record as saying that it's hard for the zoning board of adjustment to tell a landowner how to develop, like I think you were saying, it would be better if it was just 1 less unit. It would be even better yet if it were 2 less units. I think it is fair to say for this particular lot that having just 1 single-family residence on the lot probably, and requiring that with nothing else, probably would come under the hardship criteria. The question is, how far away from that do you get before the hardship to the owner outweighs the hardship perceived or otherwise to the community? So I just want to land that there. And then the other thing I would say, and this is important, I have a great deal of respect for the people in the Tide Watch community. Many of you are friends of mine, although not particularly in this audience, and I'm always running into you in the woods by the cross-country trail. You represent an important voice in our community, but you are not the entire public, and that's really important. So no matter what this board does, realize that that public criteria involves the entirety of Portsmouth. And to that point, we haven't seen a lot of input from non-Tide Watch people, and I just want to draw that to the board's attention, and also raise one other thing because it comes up later in this package, but there is some need of the public in Portsmouth for additional density in terms of the housing stock. With that said, I'm not sure that additional density serves the public entirely at 1.2 million per unit, but that's a question, and I don't want to get into that. Okay, you want a motion?
I think would be desirable at this point.
All right. I am going to move, because I'm gutsy, I am going to move to grant a variance, because granting the variance would not be contrary to the public interest in that. No, actually, I'm going to take
You
this
need
back.
a second.
No, wait. I was going to list all the criteria after the second.
We'll need a second for the motion.
Okay, let me revise my motion. I'm voting to deny the variance. I apologize. I've changed my mind, and it's not because you tisked me. It's because I want to put the denial out there. So I am voting to deny the variance.
Is there a second?
Second.
Okay, go ahead.
Okay, the reason for denying the variance is because of the hardship criteria. I'm a little concerned about 4 units on this property.
Okay, would you like to speak more to your motion?
I'm just going to ask Steph a question. Do I have to go through each criteria for a denial?
Just one.
Okay, just the one, okay.
One, or if there are others that
Whichever
are,
one.
that are not met.
For the record, I'm going to say that I don't think that granting a variance, qua variance for this property would be contrary to the public interest. I don't believe that granting a variance would not observe the spirit of the ordinance, particularly given the Tide Watch PUD behind it. However, and I don't think that it would diminish the values of the surrounding property. I think the applicant has been very clear about that. The literal enforcement of the provisions of the ordinance would not result in an unnecessary hardship to the property owner based on the plan in front of us for 4 units. I do not know whether that criteria would shift if there were fewer units being proposed. And that is because I think that a reasonable use of this property can still be achieved without 4 single residents on the property.
Okay. Does the second have anything to add? Discussion?
I think I would, I just want to make this clear. We're moving to deny the variance based on the hardship criteria.
Correct.
And the reasons that you felt the applicant didn't meet the hardship criteria, I just need a little bit more set out.
I think that the applicant has established that the applicant has come forward with a request for 4 dwelling units, and my concern is that that may be too dense for this lot, given the configuration of the lot. And so while I say that from a public purpose perspective. So let me get into the criteria specifically. And I could be convinced otherwise, to be honest, because I'm on the fence on this one. But I believe that the density of the proposal is too great, and that the public won't be served. And the reason I get there is concern about overall usage of the lot, given the character of the lot, which is a sloped wooded lot. And I just don't know whether it can support 4 individual dwelling units. With that said, that's what we're looking at. We're looking at, can this lot, given its size and its special conditions, support 4 units? And my general sense is 1 less would be better. Did that answer your question, or do you want me to go deeper?
No, that's fine.
So in other words, the hardship doesn't exist.
I don't believe so. I believe the applicant would not experience hardship with a 3 single residence development here,
Okay.
or less.
Paul, did you want to?
No.
No, okay. Mr. Rossi?
Mr. Mattson.
Oh, sorry, Mr. Mattson.
So we're discussing the hardship?
Whatever you would like.
We're talking.
Discussing the motion.
Yeah. Yeah, so just looking at the application, because the hardship is specifically with the property, not the owner or their financial conditions. And with this Walker versus City of Manchester, where hardship can be found, where similar non-conforming uses exist within the neighborhood, and the proposed use will have no adverse effect on the neighborhood. Tidewatch is a similar non-conforming use in terms of the density, and I agree 3 units would be better, but that's not particularly our call. And then I think residential use doesn't have an adverse effect on the residential neighborhood. So I agree it's a little bit of a tricky one, but yeah.
Yes.
I do want to say, I'm on the fence. I'm making a motion so that we can hash this out and
I think
act.
that's good.
That's fine.
Yep.
Ms. Record?
I just want to clarify, I had said earlier what Attorney Phoenix had said about that the property would be improved, and I think that the property could still be improved. So if we deny this, the property still has the potential to be improved. So I don't see the hardship. I just want to clarify that.
Yes.
I think, I'm sorry to say this, I think I would raise a point of order, because I think that, I think we can discuss the application without having to make a motion. I think that we do need to have a clear motion to approve or deny based upon the motion maker and the seconder's views as to whether or not the application did or did not meet the variance criteria.
I think the motion suggests it didn't, but the maker is unsure.
The maker says she's on the fence, but has made the motion, and you're right, I could have avoided and just discussed. So if it would please the board, I can withdraw my motion if the second withdraws, and we can continue to discuss without the motion being on the table.
No, I don't agree with that. I wouldn't withdraw my second.
Okay, so then we're going to hold with the motion, and I said it didn't satisfy the hardship criteria.
They didn't withdraw.
Okay, you don't want to withdraw the motion. Okay. All right, so the motion on the table is to deny.
So an affirmative vote is to,
A yes vote denies. I'm not going to support this motion. And it's incredibly difficult. But the property is going to be more, it's going to follow the rules more than, it's going to be more. And it also is going to be improved. There's going to be a curb cut. There's going to be an easier in and out safety on the road. And I think I am believing in Walker, that similarly non-conforming uses in the same area, it will have no adverse effect. I am having a really hard time seeing that this property, surrounded as it is in any way a difficult proposition for the neighborhood. I know 50 people are telling me, 100 people are telling me that's not so. But so many of the comments were also things that we cannot control. And down the road, it may turn out that there will be water issues or busting issues or something else. But for what I see, I do think this non-conforming use brings it more in conformance than prior to this. And they're still half-acre lots. These are not almost half-acre lots. So that's what I'm going to do. Are we ready to vote? Okay, so a yes vote denies the motion.
Application.
Yes, sorry, the application. Thank you. It's been a rough night. Ms. Record?
A yes vote denies?
A yes vote denies. A yes vote agrees.
Yes.
Okay. Ms. Geffert?
No.
Mr. Mannel?
No.
Ms. Murchison?
No.
Mr. Mattson?
No.
And the chair votes no. So, now we have to do it.
Yes, we do.
Okay, but this doesn't do anything yet. We have to make a positive motion.
Yes, change my mind.
I know some of those people. All right, so would someone make a motion to, so we can actually, we need a motion to approve.
Okay, I'll make the motion to approve the application as presented.
Is there a second?
A second.
Thank you.
Okay.
Please speak, Chief.
Let's speak to the motion. Okay, as I said, this is a unique parcel, nearly 2 acres, 1.94 acres on a street with a similar development just behind it. I don't know, because of the lot and the position of the lot, and because of what's surrounding it, as the attorney pointed out, it's a density request, and their density request is less than Tidewatch. It's less than Sagamore Court. Across the street is SRB, which this would probably be approved without issue. So to speaking to the criteria, 10.233.21, granting the variance would not be contrary to the public interest. I don't think the public interest would be served by having a more conforming structures on this parcel, much better than what's currently there now. 10.233.22, granting the variance would observe the spirit of the ordinance. I think it would. As we said, SRA limits 1 dwelling unit per 1 acre. They're asking for 4 dwelling units on nearly 2 acres, which would be directly across the street, SRB. And as I said before, we've got 4 dwelling units at 21,200 per square foot per unit, and right behind them, you have 122 dwelling units at 19,300 square foot per unit. So this is less dense. 10.233.23, granting the variance would do substantial justice. I believe it would. 10.233.24, granting the variance would not diminish surrounding property values. Currently, this is probably diminishing as is surrounding property values. I do not believe, now, I don't think this will have any effect on anything across the street. I do not believe it will have any effect on Tidewatch, simply because once you get through the Tidewatch thing, you're not even going to see these properties. Now, granted, the people in units 1 through 5 have stated that the size of the units through the trees, things like that. They won't be seal light and air. I get that. That's unfortunate, but it's their property. Now, the item that we're all struggling with, 10.233.25, literal enforcement of the provisions of the ordinance will result in an unnecessary hardship. A, the property has special conditions that distinguish it from other properties in the area, and owing to these special conditions, a fair and substantial relationship does not exist between the general public purposes of the ordinance provision and the specific application of that provision to the property, and the proposed use is a reasonable one, or owing to these special conditions, the property cannot be reasonably used in strict conformance with the ordinance, and a variance is therefore necessary to enable reasonable use of it. It's actually A and. The property does have special conditions. It's a well oversized lot for the area for the district. It's an angled lot. It's an elevated lot. There's only so much of the lot usable. A fair and substantial relationship does not exist between the general public purpose of the ordinance provisions and the specific application of that provision to the property. Limiting this lot to one single-family home would be a hardship, in my opinion. For 2 acres, nearly 2 acres, 4 single-family units, I see as a more than reasonable use, a huge improvement on what's there, and the request, in my mind, is not a big one as far as the density. And for that reason, I made the app.
Does the second have anything to add?
Yeah, I'll just add a few things. The first is just that this would not alter the essential character of the neighborhood. Also, I guess I would add that this large lot, it can't reasonably be subdivided based on the street frontage. Otherwise, you could still achieve more homes than one there. But because of its irregular shape and street frontage, that's not an alternative, which could create some hardship. And then the other thing I would add is there is, in terms of the purpose for the hardship, and the purpose of the ordinance is to prohibit overcrowding and allow for air, light, and separation. And there is actually still a decent tree buffer in the back portion of this property. The proposed development would push more of the 4 homes towards Sagamore Ave with a shorter driveway, and allow for they meet all the criteria of the open space requirements and all that. So for that reason, I also support this.
If there is no further discussion, I'll call for a vote.
I just have one question for Stephanie. Did your memo ask that we make the motion subject to planning board review? Is that how I read it?
No, so it's required to go to, planning board.
Okay,
regardless.
it looked like you had wanted us to state that in our
There
motion.
is a motion, or I'm sorry, there is a condition listed in there that's subject to planning board review and TAC
And TAC
review.
review. It's in
The footprints and orientation of the buildings may change.
Fair enough. I just wanted to make sure our motion was properly stated, that's all. Thanks.
Well, should we put that consideration in that stipulation?
That isn't currently in there. If you'd like to add it, I would suggest adding it.
Sure. Make the motion to approve the application as presented, subject to approvals, changes by planning and TAC.
Does the second accept that?
Yes.
Okay. I think
Are
we're
we good,
ready to
Steph?
vote. A yes vote approves the project. Ms. Record?
Yes.
Ms. Gefford?
Yes.
Mr. Mantle?
Yes.
Ms. Margerson?
Yes.
Mr. Mantle?
Yes.
And the chair votes yes. I'm never going to remember his name. Okay.
You did really
You're
well.
approved. Okay, you know what? I can call a break. Okay, we're going to take a 5-minute break.
Okay.
sorry. Oh,
I think we're
no,
just
no,
not
we're
on-
good.
there we
We're
go.
communicating now. Okay. The next item of business is the request of Jared Saunier, and excuse me for mispronunciation, for property located at 4 Sylvester Street, whereas relief is needed to subdivide one lot into 2 lots, which requires the following. Proposed lot 1 variance from section 10.521 to allow a lot area and lot area per dwelling of 9,645 square feet where 15,000 is required for each. B, 80 feet of lot depth where 100 feet is required. And C, a 9-foot right side yard where 10 feet is required. Proposed lot 2. 1, variances from section 10.521 to allow a lot area and lot area per dwelling unit of 6,421 square feet where 15,000 is required for each. B, 40 feet of street frontage where 100 feet is required. And C, 80 feet of lot depth where 100 is required. Said property is located on Assessor Map 232, Lot 36, and lies within the Single Residence B District. Who is here to speak to this?
Thank you, Madam Chairman, members of the board. I'm Tim Phoenix from Hopeful Phoenix, Gormley and Roberts, still Tim Phoenix. Thank you. This one should be a little more straightforward than the last. I'm here tonight with Jared Saunier, who's in the front row and owns the lot in question. I wanted to show Exhibit A first, which is the old plan. There you go. So this is the old plan from 100 years or so ago. I don't see it highlighted.
Okay, we have it.
It's highlighted on
It's there, but it's faint.
Yeah, it's 230, 29, 28, 227, 226. It's kind of second row up. Yeah, right. Thank you, Steph. Those are what these lots were originally designed as. All of these lots in here, or most of them, were 40 by 80 foot lots. So this one is now 16,067 square feet. So it's 5 of the historic lots. All told, it's got about 200 feet of frontage. There was a mistake in our submission that we said that the frontage for the newly created lot was 80 feet. The planning staff determined that it's really 40. We have we're going to extend the street, but it's only going to go 40 feet. The whole lot is 80 feet, but half of that is on the paper street. So the correct is, according to the staff, we have 40 feet of frontage on the new lot. So what we're trying to do is reestablish the original lots. If you can go to the C now, Steph. So here it is. Oh, by the way, Eric Sari is here from Altus Engineering. He's done the technical work on it. So the green and the orangey color is the entire lot, formerly 5 lots. And we want to subdivide by creating a small lot that's essentially 80 by 80. And the line we've chosen between the lots is the traditional line as originally established when the subdivision was done. Putting it there requires a slight variance of a little less than a foot for the proximity of the existing home to that common lot line. If the board chose, we could move that line a foot or so and wouldn't need that particular variance. Other features, there's a 20-foot utility easement that goes between the existing house and the garage. So that's what we're looking at. Steph, if you could go to Exhibit D. Okay, you probably had to, if you looked at this, you had to look pretty carefully. This was not my handiwork, but someone else in my office. We wanted to show how these lots compare to other lots in the area. Again, somewhat thinking of what's the density, lot sizes in that area, how does Walker v. Manchester fit in. So there's a little key on here. We are the blue at the sort of lower center, the rectangular lot. And then we've got a number of lots that are in purple outline with insufficient frontage. We've got the green lots are under 15,000 square feet, and lots with insufficient depth is the orange stripes. So you can see that particularly on Marjorie Street and one or two lots across the street from us, many of the lots in the area are these original, most of them have been combined, so they're 80 by 80. You probably got a letter, an email from a neighbor, Matt Turner, who, if I looked it up correctly, he's at 3 Marjorie, and he's submitted his concerns. But interestingly and coincidentally, he is, if I've got the right lot, on a lot that's the same size as the lot we're trying to create with this subdivision. I had thought, and I may have put into my submission, that but for there being a shed and I call it a lean-to, it's kind of a tree fort kind of a thing that you can store stuff under and keep it dry, we would be able to unmerge these lots as of right because they would have been never developed. But if I did say that, I just learned later today from Jared, who learned from his neighbor who used to own these lots, that there was a house on these lots at one time when the neighbor grew up in that house. So to the extent that I claim that there's a relationship between, we've almost got an absolute right to unmerge, we don't, because it was a house lot many, many years ago. So it's pretty straightforward. As I said, the lots we're creating, especially the new one, is in keeping with the 80 by 80, approximately 6,400 square feet lots in the area. I have been before this board a couple of times in the past several years. One was for Wayne Barrow's home over where Middle Street and Middle Road kind of come together, and he had an oversized lot, if you will, and made a smaller lot, which made one more piece of housing stock in Portsmouth. More recently, I think last year, we came before the board on Islington Street for the Garrett property at 1299 Islington, where they also had a lot that wasn't quite big enough for 2 full lots, but we subdivided that and got the variances for a lot that didn't meet requirements. And I think the thrust of the issue is that Portsmouth the whole state is in need of housing stock. The last one we were on doesn't really fit my issue here, which is in Portsmouth, homes are quite expensive, so finding a smaller lot in a little, that's not off Richards Avenue or whatever, will allow some family or couple to buy and live in a home that's a little more modestly priced than other places in Portsmouth. So we're asking you to give that some consideration. Turning to the variance requirements. Again, you're going to have to hear me say these same things 3 times tonight in a row. Variances are not contrary to the public interest and the spirit of the ordinance is observed. The question is, does the variances unduly and to a marked degree conflict with the ordinance such that it violates the purposes? Again, I go through the purposes of the ordinance, and I won't repeat those here, but the underlying tests are twofold. One, will we alter the essential character of the locality? And 2, will we threaten the public health, safety, or welfare? This lot, as created, as proposed, these lots are completely in keeping with the character of the locality in terms of lot sizes. I'd also mention that while this street is a street up to Jared's existing house, it's a paper street, all wooded beyond that. In fact, the street, the sign at the beginning of the street says dead end or no outlet or something. So theoretically, it could be a through street, but right now he's the last one on the left. If you go down to Marjorie, which is the next street over, there's a similar sign, and that just ends at Woods. It looks like there's a lot for sale down there now, but I'm not seeing any way to put everything together. So the effect of one more lot, a small lot in an area of small lots, is not going to change the character of the locality, and because any home to be built will have to comply with all of the code requirements as well as the zoning ordinance requirements, there's no threat to the public health, safety, or welfare. Granting the variance will not diminish surrounding property values. Again, given the size of these lots we want to create that are in keeping with the size of other lots, many other lots in this area, and considering that there was a house on the one we want to recreate now years ago, granting the variance for a lot that doesn't meet the zoning requirement, but does meet the neighborhood requirement, a la Walker v. Manchester, will not diminish surrounding property values. The next is the hardship, which is three-pronged test. Special conditions is the first one. The property as it is about twice the size of many of the lots around it. We're going to create a lot that has the existing house on it and another lot in keeping with the size of others in the area. So we believe that this constitutes a hardship, since these were separate lots when created 100 years ago or so. And once the old house came down, we don't know when that was, when the lot merger ordinances came in throughout the state, these became merged. We don't have an absolute right because there was a house and because there's a shed and what have you on it. But we think this qualifies for a hardship in the same way that the other lots that I've mentioned that were before you in the past couple of years does. Second prong is there's no fair and substantial relationship between the public purposes of the ordinance and its application here. Dimensional requirements is to prevent overcrowding, to allow for stormwater, to allow adequate site distance between neighbors, and this fits in perfectly with that overall neighborhood. So there's just no reason to apply the strict requirements of the ordinance. This will allow Jared some flexibility in terms of having another lot to sell, which will benefit him financially at some point, which is not one of your factors, but it's a life factor, which I think makes sense for him. The third prong is the proposed use is reasonable. It's a residential use in an area of similar residential lot sizes, so it's reasonable. And finally, substantial justice. The test is if there's no benefit to the public that outweighs the hardship to the applicant, this factor is satisfied. Any loss to the applicant that is not outweighed by a gain to the general public is an injustice. The variances to create a building lot, a new building lot, and you can decide whether you want to hopefully grant us the 1 foot for the existing house lot or move that lot line over so we only need the variances for the smaller lot. You can decide, but we think there's no harm to the public from granting this and from a small home being built on that lot at some point in the future, yet it does harm Jared and his family as he moves forward in his life. I don't have anything else. I don't know if Jared wants to add anything. I don't know if Eric wants to add anything, but we're all here to answer your question.
Does anybody have questions? Ms. Murchison?
So Attorney Phoenix, the lot that is to be created, what is, and I think it's on, I'm just looking, if you could turn to page, of course now I can't find it. Okay, it's page 173 of the packet. In your submission, it's C1, the sheet
Yeah, I
number
got it right
C1.
here. Can you put that back up? Thank you. Right
Okay,
here.
so the proposed lot 2, there's a building envelope there. How big would that house be in order not to have to request further variances?
I'm
So
gonna
what
have
is your bin, how many square feet would that house be?
In all honesty, I'm having cataract surgery in 2 weeks. I can't read it on here. So Eric, if you can come up and answer that question.
Good evening. For the record, Eric Sowery from Aldis Engineering. 1,212 square feet, and that's with the building setbacks per the ordinance. But you've got to remember that we can decrease the front setback using the houses within 200 feet on either side, because the house to the north of Jared's house itself is about 9 feet from the street. So the front setback can actually move closer to the street line if necessary. But we can build a 1,200 square foot footprint house with no variances and not applying that criteria at all. And that's actually bigger than his house now and bigger than a lot of the houses in the neighborhood.
So, and just a follow-up, Madam Chair?
Please.
The ledge that's on the corner of the property, that would preclude you from, you have to kind of get that house, the building envelope out of the ledge, correct?
The building envelope right now is pretty much out of the ledge. I think there's one little tiny corner on the lower left. I think that ledge is why the street stopped. Obviously, they didn't want to handle it back in the early 1900s. But we haven't done any exploratory test pits or anything like that, but I don't really see any issues with the ledge right now at all.
Okay, thank you.
Yes, Mr. Mantle.
Attorney Phoenix, you are not claiming that these were involuntary merged, correct?
They may have been involuntarily merged if the old house came down before the involuntary merger ordinances began being passed, and if there wasn't a shed and this other lean-to. Once the law is, if lots were involuntarily merged, you had to not treat them as merged. And I don't like saying this, but I would say having a shed and another partial building on the lot means it's serving the other lot, so we don't have an absolute right to unmerge them.
Yeah, but if you had that involuntary merger, you wouldn't be coming to us. You would have gone to the council for it.
Correct.
Okay. I did have something else, but, the other thing that regardless of the decision of the board, if you wanted to build a house on proposed lot 2, you'd have to come back here for a variance. There's no question about it.
Not
because it'd be a non-conforming use in a non-conforming lot. Well, no, it'd be adding on to a non-conforming lot.
It's sort of a circular issue. There is some language in the ordinance that kind of a rabbit hole, but it's my opinion that by allowing this lot to be created, you are then making it a lawful lot by virtue of the variances that you're granting. So we could put a house on as long as we don't need any other dimensional relief. That's how I interpret the ordinance.
Is there a question over here earlier?
I have questions,
Yeah,
but
I'll come
whenever.
back to you. Go ahead.
Okay, thank you, Madam Chair. I apologize for my outburst, that was
Oh,
inappropriate.
no, we enjoyed it.
I spent a lot of time out there, so nice to be back in the room again. So my first question is the paper street, is related to the paper street. So what is the plan to go and extend the paper street? Who is responsible for that? And I'm just trying to understand some details.
Yeah, a fair question. I don't necessarily have the answer to it. We did meet with the staff and talked about it. Right now, you can see that the paved portion of the driveway ends right where these two lots essentially meet. So the idea is to continue that for 40 feet on the side of the lower lot to get access to that. I don't know that there's been any discussion. I'd have to work on that with the city, the planning staff and or DPW to find out whether extension of a street is a private issue or a town issue. I just don't know.
Right, so potentially the city could be on the hook to extend this street to allow this to become a usable lot?
In return for increased property taxes, yes.
Okay. My other question with the paper street, was there any contemplation given to trying to take over part of the paper street? We've seen in the past where if the city does not make rightful use of the paper street, that your client could potentially ask for half of it. So adding another looks like 20 feet to the size of the lot, which could also then expand the building envelope. You would need to then have a zero front lot line, but you would then presumably have a driveway that would go over that. Has that been anything that you or your
We did discuss it, and we felt that this was a simpler and more straightforward path because it's not going to change anything on the ground. It might give them a little bit bigger building envelope, but it's a whole other process to get that done. There's also a law out there that says that if you have rights to the ownership of a paper street, others who would have rights to that street still have the right to use it and travel over it. Right now, it's a path to nowhere, but at least theoretically, if the city ever wanted to come in and make that Sylvester Street go all the way through again, I suppose they could do it, and that would be subject, even if Jared owned it, it would be subject to those rights of the city.
If I may continue. So one of the reasons why some of these streets, I think, never get developed is wetlands concerns. Certainly Joseph Street, I think, ends up having some concerns with that, what would have been Joseph Street. Any concerns with wetlands for the newly created lot that you're aware of?
I can't answer that. I don't know if Eric can.
I had Luke Hurley from Gove Environmental take a look at it when we started this process, and there's no wetlands within 100 feet of this lot.
Okay. And I guess while I have you up here, so at this point, you do not know what the front lot line would be. You have not performed the calculation to help you determine, how close to the front of the lot line you can actually build a
In
structure.
terms of the building setback, no, but if you look at the adjoining house to the north, it's 9 point something, 9 and change. So if you look at that lot and you take the lot on the left, which has nothing, and you average them, you're in the middle. So it's probably going to be somewhere around, whatever, it's too late to do math. So the setback would be somewhere in the area of about 16 feet.
Okay. All right, thank you, Madam Chair.
No?
He covered my point.
Okay.
Thank you.
If there are no further questions, then we're all set.
Thank you.
Is there anyone to speak in favor of this petition? Is there anyone to speak against this petition? You may come up.
Hi, my name is Taylor Andrews. I live on 1 Sylvester Street. I had written a bunch of stuff to read tonight, but I deleted like half of it, so you're just going to have to bear with me. Some of the points that Tim just brought up are pretty concerning, in addition to the things I had already discussed to myself, like the idea of the street potentially someday becoming a connection to another street really stinks, but I'm just going to read what I have. Thank you for your time. I've been coming to a lot of these meetings lately, and I've learned a lot, mostly the fact that it's a lot. So cheers to you for being able to do this time and time again. Unfortunately for me, it's uncomfortable beyond measure for many reasons, pertinently to this evening. Specifically, I certainly don't intend to prevent any person from highest and best use of their property. But as long as it doesn't prohibit the same for others surrounding, which is why I'm here. I'm really lucky to be able to afford Portsmouth, but it took everything I have, and my home is just that, everything I have. I'm legitimately concerned about the residual effects it will have on the surrounding properties, including mine. I bought my house specifically based on the characteristic of the neighborhood. It's a dead-end street with only 4 houses on it. Most of the houses have a decent amount of yard, which is a rarity and certainly adds property value as uniqueness from a lot of other properties. I purchased my home in 2018. At that time, my neighbor at 4 Sylvester was in the process of building a garage with an apartment above it, which seemed to fit nicely in the neighborhood. In 2020, the applicant purchased the property and it consisted of such the house and the garage apartment structure. And in meeting Jared, he immediately expressed his intentions to finish the apartment above the garage, move into it, and rent out the house. I thought it seemed legitimate. As with the price in homes and cost of mortgages, renting is a good way to make it affordable. As the property currently exists, such has been done. The applicant is now living in the apartment structure, and the main house has other occupants, which makes sense as reasonable use. There's now technically 4 Sylvester and 6 Sylvester on that property. By granting the variances that are being requested of you now, it's going to subdivide that property and add an additional living structure to the right of it. For a number of reasons, that would affect me. In order for Sylvester Street to have 200 feet of road frontage, the road itself, obviously, as stated, would have to be extended by a considerable amount. Therefore, by the definition set forth by the zoning ordinance, frontage on 4 Sylvester Street currently just doesn't exist. The intensity of land use in the immediate area will be increased vastly. The dead-end street will be extended from a quaint neighborhood growing from was once 4, now 5, to in the intended 6 houses. The lots referenced by the applicant have been existing lots, and they lack the required dimensional standards, and thus were used as reference for properties like the subject properties he referenced. Those lots were and have been present and were understood as such when purchased. In the contrary, Sylvester Street as a land area in itself will increase in density by a considerable measure. Where single residence B, that's single family dwellings at low to medium densities, 1 to 3 dwellings per acre. This is pretty much asking for there to be 3 dwellings on the original lot lines, which is just over 16,000 square feet. Because of the compactness of the street itself, the correlating driveways, it's already somewhat of a restrictive nature. I'm worried if they extend the street, are they also going to have to widen the street? It's already really difficult for city vehicles to make it up and down. It's difficult, it's a benefit to us as residents because it's a dead-end street. It's awesome. People aren't going to drive down it. There's not a lot of traffic. However, opening this up there's a lot of unknowns. The impact on the properties, outdoor lighting, noise, vibration, all that. Obviously, adding another house to the neighborhood is going to affect that. I mean, my sump pump runs 24/7, 365 days a year. The street has flooded on multiple occasions, so that's a very big concern. Removal of the trees where that lot is going to allow additional light from the Toyota dealership over, as well as there's like a family of hawks over there. As far as the 5 statutory tests for a variance, the applicant will not be harmed by the denial of this variance. The property currently contains effectively 2 living structures within the 16,000 square foot lot. This variance at its base is asking to add another livable structure. The proposed value or benefit to the public of providing additional housing will not be satisfied with allowing for 1 additional home. The benefit favors only the applicant as personal or financial gain without taking into consideration the potential negative effects that it will have. I am worried about my value, my property's value, as well as the other ones. You know, having a lot with some land is a big factor right now. I mean, portions of the popular market, so it's almost impossible to prove anything would diminish value, but there are certain aspects that affect certain areas. One contributing factor is that Sylvester Street, from any other street in the neighborhood comparable, its proximity to the Chase home. The Chase home is and has been a part of our community's resources, but it can certainly be a deterrent for a potential buyer, allowing for more land as opposed to more residences enhances the street's value and its character as a neighborhood. Little enforcement of the provisions of the ordinance would result in unnecessary hardship. 4/6 Sylvester Street was purchased with the street as it's currently, and to my knowledge, all ordinances were currently in place at the time. The owner applicant was fully aware of the property as its whole and its usage and purchased it knowingly.
Excuse me.
Yeah.
You are over your 5 minutes.
Oh, I'm
Can
sorry.
you wrap it up?
Yeah,
really
absolutely.
fast?
This is it. Yeah, so any further breakup or breakdown of the property, in my opinion, as much as it's great for financial gain, it's, you know, considering to the neighborhood and the surrounding properties, it's the potential to create hardship for pretty much everybody else besides the applicant. That's it.
Okay.
Thank you.
Thank you. Any questions? No. Okay, thank you. Is there anyone else to speak in opposition? Anyone to speak to, for, or against?
I'll be brief. For Mr. Rayom, I was advised by Eric that he has spoken to the city and the extension will be at the owner's expense, not the city's expense. The comment about trees on the newly created lot, Jared just told me it's 80% cleared now. There's a few trees on it. I would also mention, Steph, if you can go to this D again, the one with all the... So I'm understanding that the neighbor's lot is number 43, which is across the street. You'll see the square lot that's directly across the street, and then in front of that is the lot of the last speaker. Jared just informed me that that lot used to include both the Ms. Andrews' lot and the one that's directly across the street, and that was subdivided off some time ago, and that is roughly the same size as what we are asking for. We don't anticipate any current or future intention of the city to clear it out through there, but it's a possibility whether this is an additional lot or not. As for the rest of it, I would just rely upon what we've already argued. This is not going to harm anyone. It makes sense given the nature of that neighborhood, and we hope you will approve the variances.
Okay. I'm sorry, there was a question.
I just have a question for Attorney Phoenix. Sorry, I was a little late getting to the page. Which lot was subdivided? Is that 23243? And that was and then you had a subdivision for 23243-1.
23243 and 23243-1 were one lot.
Okay.
And that's why it's got a 1 after it, because it came out of a larger lot.
And that was subdivided by the planning board?
That was subdivided by the owner, approved by the planning board, so Jared informs me.
Okay. Thank you.
Yeah.
And, excuse me, do you know what the square footage is on those subdivided lots?
Only from what's in the information I gave you, the 23243-1 is roughly 8,000 square feet. It looks like they did the same thing. It looks like they went to the old plan and then cut off the lots as they were originally. They were 40 by 80, and so this looks like it's about 80 by 80, as far as I can see.
Thank you.
But
Just
sorry.
You done, Mr. Rossi?
Yes, thank you.
But 243.1, that had proper street frontage, so you were able to subdivide it.
He didn't.
Yes. I would argue, I would say yes, because it's on the main part of the street.
Otherwise, it couldn't be subdivided.
My point was, it's another small lot that was created out of lots out there.
Okay, thank you.
Anything else?
Are there other questions? Any questions? No. Okay, thank you. Last time, 2 for or against? Anybody to speak? Okay. Public hearing is closed. Mr. Ram.
Madam Chair, just for clarification on some of the questions that just occurred, so if you go to page 178 of our packet, it does show lot 43-1 as an 80-foot wide lot with an 82.7 foot depth, which gives it a 0.151 acre size. The other lots that we've been discussing are 80 feet by 80 feet, which is 0.147 acres. So
Okay. All right, thank you.
slightly larger because the depth is a little bit greater.
Yeah, thank you.
That helps the other board members.
Okay, what would you like to do, board? Yes, Ms. Marchison.
I don't think I'm ready to make a motion because I would like to hear what other people think. My concern is, and we had this at our last meeting, if we were to grant this variance, we would be creating a pretty small lot. And my concern is future requests for variance relief on that lot. I think the building envelope is pretty good. 1212, which doubled if it's a two-story structure, is a pretty good size structure. But that is my concern, is the possible request for future variance relief, given how very small this lot would be. So, just putting that out there.
Okay. Related to that concern, taking what's largely a conforming lot for the district and creating 2 non-conforming lots, pretty much, I would say, almost guarantees that there will be a future need for additional relief on the non-conforming lot. So it's just part and parcel if we decide to create non-conforming lots.
But those non-conforming lots conform to the streetscape really well, so I understand the non-conform means different things. Mr. Mantle.
I am going to make a motion
Please, do.
to deny the application as presented.
Is there a second?
I'll second that.
I base my motion on 10.233.22. Granting the variance would observe the spirit of the ordinance. Granting the variance would not observe the spirit of the ordinance, as has been pointed out several times. Right now, we have a conforming single-family lot, almost exactly. Road frontage is double, slightly over lot area. What they're proposing is 2 non-conforming lots. That definitely doesn't observe the spirit of the audience. While the first lot is 2/3 the size with appropriate street frontage, the second lot is 1/3 with less than half of the street frontage. That's, the spirit of the ordinance is, in my mind, to have the lots be as conforming as possible, or to get them in conforming. Now, one way to do that is just to change all the zoning and make them all conform. But that's not going to happen anytime soon. So the other thing is, keeping them, either taking a non-conforming lot and making it less non-conforming. But it certainly isn't taking a conforming lot and making it into 2 non-conforming lots. And that's why I made the motion to deny.
Does the second have anything to add?
Only that in order to just further speak to whether or not this is consistent with the spirit of the ordinance for single residents A and B, they're looking for low to medium densities, 1 to 3 dwellings per acre, and that's 15,000 square feet per. We would be creating something if we approve this that's substantially less than that, and therefore I agree with Mr. Mantle that it does not comport with the spirit of the ordinance. I also don't think that comparing the characteristics of the neighborhood to Marjorie Street is appropriate. Marjorie Street is a different street that has a different density, different lot sizes, and that's not this. Sylvester Street is somewhat different from that, and I believe that the properties on Sylvester Street are the appropriate comparators.
No, can I respond? I agree, but we're in an area town, my neighborhood, where you have a host of small lots, big lots, conforming, non-conforming, whatever. Just because one specific lot happens to be twice the size of a lot a street over or up the street, I don't believe gives you the right to make your lot, the same size as that non-conforming lot. I mean, as you see on Marjorie Street, you 3 lots, you got a very small one, 3 squares. Then you have this lot, which is the same size as the lot ahead of it going toward Middle Street, and across the street, also the same size, and you have very odd-shaped lots all over the place. I don't think we should be in the business of making more non-conforming lots. Just my opinion.
Go ahead.
Are we opening up discussion on the
I
motion?
think we are, yes.
Okay.
Go ahead, yes.
Yeah, thank you, Madam Chair. When I first reviewed this, I would have said that I would have supported the motion. However, I through the discussion that we've had and some of the things that the applicant's representative has brought up, I don't think I can support the motion. It does bother me that this is a fully conforming lot, at least in terms of square footage. It's just over at 16,000. 15,000 is the requirement. I would be especially concerned if I thought that the new lot that was being created was not buildable. I think that the applicant has made a good argument that it is fully buildable, that you can build with 20% building coverage. That's about roughly 1,250 square feet of land area. Doubling that up, you got a roughly 2,500 square foot house, decent sized house by most standards. Probably wouldn't be able to put in maybe a garage. Probably not a deck, but you could have a patio if you did it right. Not fully certain of all the topography that would support that one way or the other, but I do think with the allowable frontage and being able to move a potential home closer would create a more logical layout for such a home. And so in that sense, I do think it's buildable. I think the applicant has made an argument that the Manchester case, and it talks about something similar, which is basically that you have something in the neighborhood, and there is certainly a lot of properties in the right adjoining street, directly across. There's at least one example directly across the street that are non-conforming, and more importantly, very similar to what the applicant is asking to do. So, you do have just down the Sylvester Street, even though it's tied in with Marjorie Street, you have another essentially same size lot, the one that was created directly across the street. And then on Marjorie, which is just one street over, backing up against this property are a whole series of lots that are either the same size or in one case has the original 1903 dimensions. Certainly they were very optimistic back in 1903 regarding how they were going to sell these lots and create like a mini downtown, very dense setting. That clearly didn't happen, but at the same point in time, I think that there's some pretty apparent that the two 40-foot wide lots properties do abound in this sort of little micro neighborhood. So I just think we're on shaky ground if we deny it based off of the spirit of the ordinance. I'm not seeing where there's enough there to say that they aren't in accordance with the spirit of the ordinance. The one thing that you might have is also the 40-foot frontage versus 80-foot. But again, I think there's a unique hardship associated with that, where you do have the end of a paper street. The applicant, at their own expense, will be extending said street, and with that, that they would, it doesn't seem to make sense to make them extend it the full 80 feet and pay extra money for a street that essentially goes nowhere. So I don't know, I'm going to vote against the motion. That's all. Thanks.
Yes.
Yeah,
Matson.
I guess I'll just add my comments. I mean, I like the idea of trying to create more buildable lots in Portsmouth because there's a scarcity and it's really desirable to do. And I recognize there are plenty of non-conforming lots in Portsmouth, but I do struggle with the idea of us creating 2 non-conforming lots out of one that is closer to conforming. So, yes, that's where I'm at right now.
Okay. Any other comments? Yes.
I just want to address one thing that you said, which was that this, because you convinced me and then Member Rayom convinced me the other way. You said that the requested variance may conform to the surrounding neighborhood, may result in lots that conform to the surrounding neighborhood, but is contrary to the ordinance and the way the ordinance is written. And yet, I think there is something to be said for what is in the surrounding neighborhood. And I'm going to pull from your last discussion where you looked behind the lot to the PUD behind it and said it's very similar. And so the one thing that I noticed is the lots that would be created here are very similar to what's surrounding. I have a question for Stephanie, which is, I think that there has to be some, like, for me to feel that this is not contrary to the public interest, I'm wondering, can we include something that requires the extension of the street by the lot user? Because I think there is the potential for somebody to get a non-conforming lot that fronts on a paper street but doesn't front on a real street, and to somehow say that the city owes them, extension of the street plus dedication and all that. I would just ask whether we can do that.
That's a tough one. I would hesitate to do that just because those details will be fleshed out in the technical advisory committee review as far as what sort of access is appropriate and how that's maintained.
Okay, and that just feeds into denial or not for me, so thank you.
Okay.
Yeah, to answer your question, if I understand it, and if I'm wrong, I'm sure somebody will correct me, you would add that to an affirmative motion.
Right.
To your point, though, going back to the last application, would this create a lot that looks like other lots in the neighborhood? Yes, it would. Does the lot as it is look like other lots in the neighborhood? Yes, it does.
Fair point.
So, as I said, I don't know how those other lots, this is clearly a subdivision taking a conforming lot into two non-conforming lot, one grossly non-conforming. Whether it has a building envelope that's big enough is irrelevant. This is a big ask in my opinion. Why I made the motion to deny.
We ready to vote? A yes vote denies. Did you want to speak?
No.
No.
I just was clear on
who's the vote?
whether
We're
we're
not
voting or
voting.
not. We're
Oh,
not
I'm
voting.
so sorry. I'm so sorry. We'll do it in alphabetical order. We'll start with Ms. Geffert. Okay. Sorry. I was so used to just. Okay, so I just don't know how I'm going to vote yet.
I know.
It's okay, we'll find out in due course.
Okay, we will. Thank you. All right, so
Why don't we start with that end?
Ms. Geffert.
Oh, darn. I'm going to vote no. That means I don't agree with the denial.
A yes vote denies the motion, a no vote allows.
Denies the variance request.
Yes, thank you. I do this, yes, I know.
Yes.
Yes.
Mr. Mattson, we taking it up?
Yes.
To deny, yes?
Yes.
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 No.
And the chair votes no.
So
what do we
that
have?
carries, and it's four to
Three.
whatever, three.
You have your approval.
No.
No, you don't have your
Denial.
approval, I'm sorry.
Denied.
Sorry.
I couldn't. I thought you were shaking your head.
Sorry, I was agreeing with
Yeah.
the,
Right.
the
All
town.
right.
Yes, 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 yes. Yeah, 4-3.
Okay.
Can we get an easy one?
Hmm?
Can we get an easy one?
You know, I thought they were till I looked at them again today. Okay.
I know.
I don't think this is it. So, the next item of business is C, the request of Cynthia Austin Smith and Peter, owners for property located at 9 Kent Street, whereas relief is needed to demolish the existing two-family and construct a single-family dwelling, which requires the following. 1, variances from section 10.521 to allow a lot area and lot area per dwelling of 5,000 square feet, where 7,500 square feet is required for each. B, 53% building coverage, where 25 is the maximum allowed. C, a 4.5-foot rear yard where 20 feet is required. D, a 0.5-foot side yard where 10 is required. E, a 0-foot front yard where 11 is allowed under section 10.516.10, and F, a 9.5-foot secondary front yard where 13 feet is allowed under section 10.516.10. 2, a variance from section 10.515.14 to allow a 1.5-foot setback for mechanical unit where 10 is required. Said property is located on Assessor Map 113, Lot 42, and lies within the general residence. Is there
Thank you.
anyone to speak to
Madam
this?
Chairman, you'll be rid of me after this one.
Okay.
Tim Phoenix from Hopeful Phoenix, Gormley and Roberts, here with and on behalf of the Smith. Peter is here. I don't know if, where is he? Oh, there she is. They're both here, Cynthia. Also with us here tonight is Jeff Stacy, who's the builder. I thought I saw him. Is he still here? There he is out back. John Shagnon, who's done the civil work on it, Jen Ramsey, who's done the house design work, Robbie Woodburn, where's Robbie, who's behind me, who's done the landscape architecture work, and Mike Sievert, who's done the structural engineering. We originally submitted this back in March. After that, the owners had some, the neighbors, the Michaelides, who live, if you're facing the house on Kent Street to the right, expressed some concern about the proximity of this new house to their house, to theirs, to their property. So more recently, you got a letter from Jen Ramsey from Soma Studios and a plan that shows that the foundation wall on that side is going to be moved to the left about 3 feet to create some more room. The house size is going to stay the same because that 3 feet is going to be cantilevered over the ground. Which is going to help with some drainage issues. We have a very small lot. It's 5,000 square feet, 50 by 100. It's in the general residence district. It's got a duplex on it now, side by side, with porches and what have you. There is a so-called garage at the back of the property if you've been there, but it's not accessible by vehicles because there's a very steep, short hill from another paper street to get to the garage. So right now, there's only on-street parking. The proposal calls for building a new home on the lot, essentially in the same location as the existing home. There are quite a number of variances that the chair read. We acknowledge that there are quite a number, but if you look at the relief chart that I've submitted which is on page 3 of my memorandum, you'll see that the numbers aren't all that differently. In other words, if you built the house that's there today in that location, you'd need many of these same variances. A couple of the things that we are doing, boy, that's small. Thank you, Steph. A couple of things that we are doing in particular are creating a garage under. It can fit 2 cars. So we will have off-street parking, which does not exist today. The lot size isn't going to change. Right now, we're between 7.5 to 9 to 17 feet from the front. There's a landscape wall now that's going to hold fill and be planted. That's on the property line, but I'll let Robbie address that. Oh, and by the way, I forgot to ask at the beginning, we've got several people who really need to address some technical aspects, so I'd like some extra time. We may be able to do that in the second round, but if I can get through this quick enough, I'll turn it over to at least John Shagnon and Robbie Woodburn, and then others as needed. The existing building coverage is 35%, and what's proposed is 53%. It seems like a lot, but the reason for that is that in the backyard, if you can go to the site plan, Steph, the backyard is going to be raised from existing ground level by 24 inches. And then on top of that is going to be a pervious patio, pervious pavers. The reason for that is to create better drainage impacts. If that fill was 6 inches less, we wouldn't need some of this relief. But because it's over 18 inches from existing grade level, we have to include it in our building coverage. If you take that out, then we go from 53% to about 39%. And we are at roughly 35 or 34% today. So that is something that I ask you to keep in mind, because it's kind of an artificial requirement to include that in the coverage, just because your ordinance says that if you're doing something that's more than 24 inches above existing ground level, and we are filling, and then we're putting a patio over it, then you have to count it. The existing garage is 5.5 feet from the rear line. We're going to have a landscape wall that's 4.5 feet. A privacy fence on top of that. There's some pool equipment that's 10 feet away where 20 is required, but there will be significant landscaping all around the entire perimeter of the home. On the side yards, we've got the house is 0.7 feet. We're going to be at 0.6. The garage is at 1.7. Again, we got the same landscape wall that's nearly on the property line. We've got an AC unit and some pool at 1.5 feet, pool equipment at 11.5 feet. So there are differences, but they're relatively the same. The house now is covering the whole lot. There have been a number of letters submitted to you. I counted I think 4 or 5 letters of support, strong support, and 4 or 5 letters of opposition. You should have those. I would say that there's been some comment made that, well, why can't you bring the house in so you don't need these side setback variances? Well, if we did that, in order to maintain the comparable living space, the house would get significantly longer. So from a view of its impact, it's going to look more imposing than this house, which is shorter. It's a little wider, but roughly the same width as the existing home, and allows us to have more of a backyard. The numbers I have in support are Alex Greiner at 88 Lincoln, Randy Gursky at 55 Kent, Kevin O'Connell at 140 Elwyn, Brandon and Tara Seppa at 151 Elwyn, Adam George at 134 Lincoln. And for opposition letters, I have Janet Schofield at 36 Kent. I don't know if it's Karen Danger, didn't have an address, but somewhere on Kent Street. Stephen Schmidt, it just says he's in the neighborhood. And Richard Adams at 75 Kent. And I'm going to mention him specifically because he commented upon taking parking on Rockland Street? Rockland Street that would be taken from the public. Well, first of all, we would think that the property owner whose house is right there would be entitled to park there, but as I mentioned earlier, we are solving that problem in large measure by the garage under. So if the board would indulge us, what I'd like to do now, before I go through the variance requirements, is turn this over to Robbie Woodburn and let her, because she's got the details of the, of what's going on landscaping-wise. She gave me a summary, which I think she expected me to go through, but I'd much prefer that she do it since she's the one that's lived it. And then I'd like John Shagnon to address specifically drainage issues, because it's...
We have some time, so
Okay.
why don't we?
Thank you.
keep it,
Robin?
And then we'll see.
So good evening, I'm Robbie Woodburn from Woodburn and Company Landscape Architecture. Tim did cover the main point I wanted to make about the building coverage numbers, which look so inflated because our patio, which is usually, if it's 18 inches or less above grade, it doesn't count as building coverage. We're 24, so that we get our clearance and our available area for drainage infiltration, because we're doing a pervious pavement. So Stephanie, can you go to the landscape plan? So several things drive this plan, one of which is the driveway that goes down into the lower level for the garage. That sets the grades of the house. The pervious pavement sets the grades of the rear patio. The topography of this neighborhood goes from the bottom of the page. The bottom of the page is higher, and it goes down towards the park, which is on the top of the page. The neighboring property is 3 feet above the current elevation of the backyard. So the neighbor's property at the elevation of the property line is 31. At that elevation, there's a retaining wall that goes down to the 28 elevation of our existing backyard. And on that retaining wall on the neighbor's side of the property, there is also a 4.5-foot high fence. So our existing elevation at the backyard is 28. We're raising it to 30 for the pervious patio. We're still a foot below the yard on the other side. Then like anyone else that wants to have uses in their backyard, we want to put a fence around that yard. Our landscape wall counts as a fence. However, because it's on top of 2 feet of fill, it no longer counts as a fence, because it becomes a structure because it's taller than 6 feet. So that's why we're asking for relief for the wall. In the case, that wall, that 6-foot wall, wraps around the southern part of the property and the eastern part of the property, and then 2/3 of the way through the eastern property drops down to a 4-foot high glass railing. So those two walls that we're asking for relief for, one of which is mitigated by the grade change, and you can see it in the section on the right here, by the grade change. The top of our landscape wall will be the same height as the neighbor's fence. So our wall will not be cutting off the views they already have going across to the park. The team had discussed that with the neighbor, so they're aware of that. The pergola, which you see in the corner there, it's a dotted rectangle. It is located right where the existing garage structure is, and behind their chicken coop. So those things that you would think would be impact the neighbor are in the same place that the garage already is, and are lighter and not as massive as the garage itself. The wall on the landscape wall on the eastern side of the property, facing the park and facing this building, again is the 6-foot high wall on top of 2 feet of fill. So, actually a 5.5-foot high wall on top of 2 feet of fill will be planted with large evergreens to negate that, to screen that wall. I just want to make sure I've covered the things I wanted to tell you. Oh, and we're also asking for relief for the landscape walls along the front of the property and side of the property. The ones on the side, on the Rockland Street side, are walls that allow the hold the grade so you can go down the ramp into the garage, and the walls in the front are short, very short walls to flatten out the front yard. If you drive around the neighborhood, within 500 feet, there are at least 5 or 6 other houses with the same kind of condition, with stone retaining walls, concrete retaining walls, segmented block retaining walls, so it isn't something out of the question. So many of the variances that we've asked for are landscape driven in those respects. So they, unlike architecture, they have not quite as much impact, and we've tried to mitigate them as much as we can, working with the grades on the southern side and planting on the eastern side and working with the idea that other homes in the area have retaining walls at their front and side property lines. Those retaining walls along the side are mostly 2 feet or less, except when we turn the corner to go down to the garage. So I think that covers the points I wanted to make. I'll answer any questions you have.
Other questions? No. Okay, thank you.
Great, thank you.
Thank you, Robbie. So may I have John Shagnon come up and address the drainage issues while we're going, or do you want to wait?
There's time. 6 minutes.
Thank you, John Shagnon from Ammon Engineering. If we could go to the grading plan, Stephanie. I think you can tell from this plan set that there's a bevy of experts that have gotten together to try and meet the needs of the applicant. The applicant wanted to have a garage, off-street parking, and if you look at the table of dimensional coverages on sheet C2, there's an existing structure and a detached garage, which are very similar in size to the proposed combined structure. The garage is moved into the building and put at the lowest level, coming off of Rockland Street. In order to do that, it comes down from the street to get to the lower level. So the garage is incorporated into the basement of the structure, which means the structure will be smaller in size, but it also has some challenges with drainage. And one of the features of the plan is that as that slopes away from the street, we need to deal with the drainage that's going to come and fall in that sloping driveway as it heads to the basement. So we've developed a catch basin and piping system that will bring the drainage out to Rockland Street, and in consultation with the Department of Public Works, it became clear to the department that we could incorporate some features that would help the situation in the neighborhood. Currently, runoff that comes down Rockland Street continues on and runs into a city playground and creates some issues with that playground. So as a part of this project, the applicant is going to put in a catch basin and redirect that drainage into a closed system, which will be a benefit to the adjacent playground and park area. Also, in order to not impact the abutter on Kent Street to the south, the main ridge line runs east-west, and runoff could potentially fall onto the neighbor's property. So a part of this application is to capture that roof runoff and divert it to an underground storage and bleeding system that would be located in the backyard. That system, in order to function properly, has to be set at a certain elevation above the groundwater table. And we did the appropriate testing and found that that level had to be such that this patio that has been talked about a number of times, and I'll state it one more time, in your ordinance, open space is described as areas that are open and could be walkways and terraces if they're porous, which this is. However, because of the grade that is necessary to put in the proper drainage, if I could have made it lower, it would have made it a lot easier, but I couldn't. That then becomes a structure, and the definition of open space excludes structures. So that's why the porous patio is part of the request for the structural relief. So just to say that one more time. That's the plan to deal with the water. We've tried to incorporate a lot of the aspects that meet the client's needs, but also protect the neighborhood. If you have any questions, I'd be glad to answer.
Any questions? Okay, thank you.
So being mindful of the
1 minute.
rules. 1 minute? Then I'll probably just have you open it up to public hearing, and I'll come back in second round and go through the variance requirements. The only thing I would point out first is, which button do you push it? What did I do here? I just shut it off? Oh, how do you make that circle thing work? There we go. So this is the area, the patio that we're talking about, that John's talking about, and that I mentioned earlier, and that's 668 square feet. And that's where, what I'm asking you to consider that is really artificial. So if you deduct that 668 from the 2,660 total structure impervious, it brings it down to 1962, which is about 39%, where existing is about 35%. So it's a far cry from the 53% that we are technically asking for. Thank you.
Madam Chair, do we have the opportunity?
Yes, could you, there are questions.
Thank you. I
Go
do
ahead.
have a question. Attorney Phoenix, with regard to the right yard setback of about half a foot, that is for the house, that's due to the overhang, is it not?
It's due to the cantilever of the as we mentioned, the wall is being brought in, the basement wall. The house floor plan is staying the same, so that's cantilevered over by 3 feet. And then is there a small overhang, Jen? A roof eave?
Well, roof and just the sheathing on the house and the siding as compared to the actual concrete wall.
Right.
That's that little bit.
So with regard to that specific variance, I know you haven't had a chance to go through the variance criteria because of time limitations, but what would you say is the hardship of the property that requires cantilevering the house and bringing it right up to the lot line?
Again, many houses, back to Walker v. Manchester again, there are many houses along this area that these are small lots and the houses are very close to the lot line. The Michaelides house in particular is pretty close to the lot line, which is why there were some concerns that were expressed that we tried to address. And we think it deserves favorable review and consideration by the board to essentially put this house in the same location as the existing house. It's a little off here and there. A lot of that is the walls that Robbie described. Some is the house. That's what I think supports our request.
And how close would the two walls of the structures, like the external walls of the structure that you're proposing or your client is, and the neighboring property, what is the gap between those two walls?
I don't know exactly. John, do you have an idea?
If I can also address your question a little bit, part of the reason that the house is pulled to the south is due to the desire to park in that basement level. So Rockland Street is at a fixed elevation, and in order to get the car safely off the street, down and under the structure with enough clearance so that we don't have to keep raising the height of the house, that forced us to push that house in that same location that it exists now. So there is an engineering reason that the house is that way in close proximity to the existing setback. So
So the current condition is the house on the right side is about 0.7 feet from the lot line, is that correct?
yeah, I would
So
say that's
it's
about right.
essentially the
Yep.
same, okay, thank you.
It's very close, and but the need to get underneath and have clearance and have a driveway that works also contributes to that location.
Thank you.
To further answer, Mr. Rossi, Jen just pointed out that the existing is 0.5 feet from the
I got that, thank you, I didn't realize that before.
Just
Thank
in my head, when I answered your question earlier, I thought the Michaelides house was even a little closer, but it's got to be, I don't know, 5 or 7 feet. Yeah. In my head, it was, right on the
you. Okay,
line.
no, that's fine, thank you.
Okay. Yes.
Can we continue to ask questions?
Yes, I didn't know, I'm sorry, I didn't see that anyone had a hand up.
I have
You
questions
may come
for the applicant. If this is the time I want to do it. I would.
Yes, I
Okay.
didn't know that you would.
All right, thank you. So on page 188 of our package, which is page 4 of your narrative, so you go through the criteria. Your first one is the use of land, buildings, and structures for business, industrial, and residential, and other purposes. You state here, the project proposes a permitted single-family home where a duplex presently exists. So redevelopment is more conforming compared to existing conditions. Very confused by this, since this is in the General Residence A, and 2-family homes are permitted in General Residence A. How is this making them more conforming?
That is a misstatement by me. The intention was, what I should have said was, it's less density by fewer units, and it's probably, I think, better in comparison to others. There's probably other multifamilies, but it is, since 2 families are allowed, that conformity statement is incorrect.
Okay. Down to number 5, this project will replace an aging duplex with a tasteful new home and beautiful landscaping screening. So a lot of times when we have applicants come before us regarding tearing down an existing structure, we get a tale of woe. It's fallen apart. It's rotted here, rotted there. This just describes an aging duplex. Is there any similar concerns with this structure as it currently stands?
I'd have to ask the experts that, either the owner or, I don't know who's been in the house. I've never been in it.
The house is extremely outdated. I have been in the house.
I'm sorry, we cannot. No.
I'm not qualified to say whether the house is, ready to fall down or whatnot.
May need to have them identify themselves.
Yes, please tell us who you are.
Oh, I'm sorry. I'm one of the owners, Peter Smith.
Okay. So do we have an illustration at all of this proposed cantilever? So you're now talking about making the foundation smaller, but cantilevering the first floor. Like, what's the gap going to be between the ground and the first floor? This sounds very odd, and I don't think it's something. But we don't currently have anything in our package that illustrates this, correct?
We submitted, Jen Ramsey submitted a letter on May 8th, sort of explaining it. And there was, by John Shagnon, a complete set of plan sets submitted on or about the same date, right?
Is that in our package?
Yes, you have the updated package. Maybe John can identify which pieces have changed since the last submission.
So the cantilever, I can explain that it's more to do with the structural and the constructability of the replacement home. When you're building that close to the property line, as it turns out, you can do a number of things to construct. One would be to sheet pile and put in the new wall, because you have to dig down and you have the possibility of damaging the adjacent property. So in this particular case, the structural engineer has worked out a situation where the existing foundation wall will be used as the sheet pile or the sistering, the thing that holds up the earth while the new wall is built. But then once you get above the grade to the first floor, then you can construct the rest of the building without impacting the earth potentially.
Yeah, so this is going to look like a 3-foot porch with no support underneath it coming out.
The gap will not be great, and you can talk about
Jennifer
skirting.
Ramsey with Soma Studios. You're not going to see a floor floating over the grade. So there's the original foundation wall of the home that's there now, does not change. We build a new wall inboard of that. The floor above, the new framing, is going to float over, and we're going to be able to side down and create a condition that you will not know the size of the foundation below from the exterior perspective of this home. You're not going to see something that looks like it's floating or a cavity, for instance. This is not an uncommon detail. A lot of decks are like this, and then you will apron them and build them down, or bay windows are then sitting on posts, but then we actually sheathe around them and side them or trim them out, and you never know that there's actually cavity space under there.
Okay, I mean, this is a lot larger than a bay window or a small deck, but okay, all right, I guess I understand that point.
Are there other questions? Any other questions? Okay. I think,
No, for now.
I think we're good for
I'll be
now.
back.
Okay. Is there anyone here to speak in favor of this petition?
Hello, my name is Dean Baltalonis. I'm a resident at 159 Richards Ave. So my home is adjacent to the same park.
Yes.
My family and I use that park on a weekly, if not daily basis. I feel the current house is a bit dated, and I think the plan that they're going to do will be a much welcome upgrade to the backdrop of the park.
Okay, thank you. Anyone else to speak in favor?
Hey there, my name is Jessica Kaiser. I've been in Portsmouth in Little Harbor neighborhood for 20 years now. I own 7 properties here in Portsmouth, both commercial and residential, so I take any real estate decisions we make here in Portsmouth very seriously, and I'm very mindful of the choices we're all making here today. I'm in full support of the proposed plan that the Smiths and Jennifer Ramsey has put forth for the Kent Street property. I, first of all, very much support the architectural design that they've come up with. I think the architectural elements show some modern components, but also do a great job of blending together elements from the existing house and surrounding houses. So while it does have a bit of a contemporary flair, I think it brings in a great little modern farmhouse component, which is a nice balance to Tatiana's house right down the way on Elwyn. It also complements many of the other modern farmhouses that are being built in Portsmouth today, as well as the one I'm building on Wybird Street. In addition to that, I also support the kind of the overall proportional component of the property and how it fits into the landscape in the neighborhood. I applaud Jennifer's work in terms of developing this property so that the garage actually sits, so the garage and some of the functional space actually sits underground, so it doesn't impede the overall mass structure that's coming up above the ground. In fact, I think from what I understand, the overall footprint is not growing more than 300 square feet of the actual house itself. So overall, I think the house will look quite beautiful and proportional, both from the street on Kent Street, as well as when we're looking up from the park and the tennis courts from below. In fact, just this morning, I was playing tennis at Mill Pond, and I was looking up at Tatiana's house, and I was really admiring how beautiful her property was. They've done a great job, and obviously you guys had approved that. And I look at that cityscape, and Kent Street is kind of a critical house. You know, that house right in the end is a very critical component of that cityscape that we see from Mill Pond, where so many residents and so many tourists gather all of the time. Right now, the property, that duplex we have, one is a duplex, two, it is very run down. It would be very hard to renovate as is. The designs that they put forth, I think, are beautiful, and I would love to see that design contribute to kind of the dynamic cityscape that we have from the view of Mill Pond. So I'm 100% in favor of the plans they put forth.
Okay, thank you.
Thanks you. Thanks for your time.
Anyone else to speak in favor of this petition?
Hey, good evening. Oh, how's that? Long evening. No, appreciate your time. And my name's Alex Greiner. I live at 88 Lincoln, so I was one of the letters referenced that you probably already have. Probably can't say it as eloquently as the speaker before me. We're short-timers in Portsmouth. My wife and I moved here, or 4 years ago. We underwent a large construction project as well, so I can empathize with the time, the effort, the cost, and the consideration as you think about what you want to approve and why. I will say this: I can't speak to the condition of the house. I walk by the property every day with our dogs. We have 2 young girls that use the park on a multi-weekly basis. I know Peter has taken me through the plans and the pictures and the designs, and I know that what he's proposing will look amazing in that spot. The previous speaker referenced Tatiana and Brent's home. It's a very prominent one on Rockland overlooking the park. The time that I've been here, SAI Construction has built another nice home overlooking the park. It's a brown one right across the way from that. So this would be an amazing addition to the neighborhood in terms of what they propose structurally. The design looks spectacular to me. The size of the house, I learned a lot more about the technical aspects myself, but the size of the house in terms of the renderings and what I could tell you from my layman's terms does not look imposing or overbearing. It looks like a wonderful single-family home that would be on the corner over there, and would bring another family of four into Little Harbor. I've got two little girls that go to Little Harbor and would love to have yet another family move into the neighborhood. I know a lot of families are getting priced out, even in the times that the few years that we've been here. So would love another single-family home and a family with young kids to move into the neighborhood. So strongly support the project. Thank you.
Thank you. Anyone else to speak in favor? Is there anyone to speak in opposition to this proposal?
Hey, good evening. Thanks for having me. I'm Dave Michaelitis. I'm the abutter. I'm going to go through my prepared comments, and if I have time or remaining 5 minutes, I will try to rebut several comments I heard this evening. First and foremost, thank you for the opportunity to address the proposed development at 9 Kent Street. As the only direct abutter, the owners have reached out to us to discuss some of our concerns regarding fence height and the stormwater runoff based upon the construction of the new foundation. However, after reviewing the application submitted, we are strongly opposed to the proposed development for the following reasons, using the 5 criteria for the variance. Criteria number 1, the variance will be contrary to the public interest. Public parking currently exists along both sides of the end of Rockland Street where the new driveway is proposed. This is frequently used as people enjoy the South Mill Pond complex during all seasons. The new driveway the applicants are proposing will be making it impossible for them to exit their driveway if cars are parked on Rockland Street. It will only be a matter of time before they ask that this end of Rockland Street become a no parking zone. Criteria 2 is the spirit of the ordinance observed. The applicant is asking for 7 variances, so no, the spirit of ordinance is not being observed. This is not a vacant lot. There are existing structures on the lot with zoning laws in effect that they knew about when they purchased the property. No one is denying them the use of the land for their residence. If a new development is being constructed as they describe, this new development should conform to the prescribed ordinances and not require additional variances beyond those that already exist. Demolishing a home doesn't guarantee the grandfathered footprint to rebuild 6 inches from your property line. Their proposed design only takes into account their property, but not ours in regards to the impacts of stormwater runoff. They're changing our site conditions, increasing stormwater runoff onto our property, and potentially leading to flooding in our basement. They are proposing a metal roof on their new home that is now oriented north-south and not east-west. The snow will now slide off their roof onto our yard, creating a hazard to anyone underneath it, because as you alluded to earlier, the overhang comes onto our property. They're also causing us concern since our gas meter and other utilities are located on this side of our house. You'll also notice that the foundation wall along the property line is now longer because they are planning on completing a finished basement underneath both their front and back porches. This impervious concrete foundation will increase from 38 feet in length to 55 feet in length, 8 feet deep, 6 inches from our property line. Now we have an impervious wall barrier that completely changes our site property drainage. Where does all this snow and rain end up going? And what is our recourse if we end up with water in our basement? The consideration of a French drain on the application submittal doesn't change the roof slope nor allow them to maintain it without digging up our property. The stormwater treatment plan is predicated on existing and routine maintenance on a biannual basis that requires them to use our property for their cleaning of their premises. This proposed development will have a negative impact on preserving the essential character of the neighborhood while impacting the visual environment. The applicant states that they are replacing an aging duplex. Their aging duplex is similar in age to every other home on the street, and everyone else found a way to renovate their aging structures while preserving the character of the neighborhood and the visual environment. I have been in that aging duplex that they call aging. Contrary to their application, they are decreasing sightlines and destroying the visual environment by one. They did not address the fact they were building a front porch and home that will be further forward than any house on Kent Street in comparison to anyone else, thus impacting the visual environment. The variance requires a 10-foot setback for their air conditioning unit, yet they plan on placing it 1.5 feet away from the property line, when there are plenty of conforming locations for it. Criteria number 3, granting the variance will not diminish the surrounding property values. Those proposed variances that reduce the existing setbacks or alter our visual environment, cause us potential harm due to falling snow and ice, increase stormwater on our property, possibly flooding our basement. Criteria number 4, denial of the variance results in unnecessary hardship. There are no special conditions to this lot. It doesn't result in a hardship. The lot is not vacant. There are existing structures with zoning laws in effect that they knew about when they purchased the property. By their own admission in their application, they acknowledge that the property is small and narrow. I fail to see how granting all the relief that is requested is reasonable given the existing structures and layout. Is the lack of underground off-street parking, a swimming pool, outdoor kitchen, and extensive seating area considered a hardship? Criteria number 5, substantial justice. Building a new home should not exempt you from conforming to current zoning ordinances. The applicant is not constitutionally allowed to ignore zoning ordinances in effect when the property was purchased. The ordinances did not change. They were fully aware of what they were allowed to do when they purchased this lot.
Excuse me, sir. You are at your 5 minutes. Could you wrap up, please?
Yep. In summary, we believe that the applicant's proposed development could have made a better attempt in meeting the spirit of this board's oversight and intent, not what appears to be the exact opposite. There is no hardship. This is not a vacant lot. The variances requested are contrary to the public interest and are not in the spirit of the ordinances this board is in charge of. The proposed new development is exasperating a pre-existing non-conforming condition and making it worse by increasing the intensity of the land use and decreasing yard size, setbacks, and open space. For all the previously stated reasons, maybe this is not the correct lot for the size of the structure being proposed. Thank you.
Thank you. Is there anyone else to speak in opposition to this proposal?
Good evening. My name is Bill Arakian. I live at 18 Kent Street. Just a couple points, I guess, before I give my written comments. Some people have referenced Tatiana's house. I would point out that that house did use the existing footprint in the existing house that was renovated to make it what it is today. And as far as dated, I would say that the existing property as it stands today is structurally sound, vinyl sided, new roof. I don't think there's anything that I would consider dilapidated by any means. So anyway, I lived at 18 Kent Street for the last 20 years across from this property. One thing I'd like to bring out or talk about are the setbacks. The existing lot on 9 Kent Street, where it resides, does not present any undue hardships, and the sheer number of exemptions required underscores the inappropriateness of the proposed design. Given that this is a completely new build, there's no reason to drive all the setbacks either out of compliance or further out of compliance, therefore not fulfilling the spirit of the ordinance. The lot size is identical to the majority of the lots on Kent Street. It is level, and it currently has one of the largest homes on Kent Street on it. The proposal seeks to enlarge the overall structure, expanding and moving the foundation 8 feet forward from 17.3 feet today to 9.3 feet, reducing the setback along the entire front of the residence on Kent Street. The proposal also includes a full-length porch along the entire front of the residence, as well as a bump out built atop the 8-foot expansion. Besides encroaching on the setback ordinance, it would also negatively impact neighboring views and sightlines. On the Rockland side, the setbacks go from in compliance at 15.7 feet to out of compliance. On the south side of the property, the proposal reduces what is already a setback of only a few inches and adds mechanical units. Coverage, which is currently 35%, proposed to increase to 53%, and even without the patio in those calculations, the coverage is driven further out of compliance. Retaining walls, despite what is today a level lot with no retaining walls, also included in the proposal is a request for a 0-foot setback on Kent Street to ring the property with over 300 feet of cement walls and fencing. A section of the cement wall facing Langdon Park is 6 feet in height. Currently, many of the homes on Kent Street have no fencing facing Langdon Park, and none of the homes on the street have fencing in the front yard. The few properties that do have fencing facing the park have a simple 4-foot wooden picket fence, not 6-foot cement walls, which would be completely out of character for the neighborhood, the park, and for Portsmouth. Despite suggestions of landscaping to help obscure the public's view of the wall, I feel the proposed walls run contrary to the public interest and would be a detriment to the public use of the park meant for the enjoyment of nature. In my opinion, this ring of cement and fencing encircling the property referred to in this application as a secluded outdoor living area provides more of a fortress-like feel that does not integrate well with the neighborhood or the park. Runoff, another aspect of extensive cement walls on what is today a level lot, is water runoff. Today, runoff is handled naturally, being slowed and filtered by the surrounding park. This would be replaced with a system of cisterns and piping that will concentrate runoff and require maintenance. This site has never required a storm water management plan. It is another impact of the current proposal that runs contrary to the public interest. Finally, an important concern regarding the addition of a driveway on the Rockland Spur. The proposal eliminates current parking spaces and introduces potential safety concerns. I did not see any reference to parking within the application, but the turning radius to access the proposed driveway would require elimination of parking on that spur, and the impact would diminish access to the park and its numerous uses and result in more visitor parking being pushed into the neighborhood. Also, with limited line of sight due to concrete retaining walls, there's potential for increase of safety risk to frequent pedestrians, as well as many children who play in that immediate area. I would recommend the board not support this proposal. Thank you.
Thank you. Is there anyone else to speak in opposition?
Good evening. Good evening. My name is Cliff Hodgson. I live at 10 Kent Street in Portsmouth, directly across from the property under discussion tonight. My family has owned 10 Kent Street and lived there since my great-grandfather had the house built on the corner in 1902. I am a Portsmouth native and I grew up right there. As a historical note, number 9 Kent Street was built as a single-family dwelling after 1900 and was converted to a duplex in the 1950s. The exterior of that house has had only minor changes since 1910. I strongly disapprove of granting a front yard zero lot line variance facing Kent Street. For permission to do landscaping is different. Having such a variance might encourage them to build closer to the sidewalk more than just a cement wall. The proposed house is intended to be 3 feet closer to the Kent Street front side of the property, exceeding the front line setback. This will adversely and directly impact the sight line of the adjoining homes. It will block the next door neighbor's view of the park, diminishing their enjoyment and value of their home. The new owners may have consulted with the neighbors, but that does not mean that they received approval or acceptance. The Rockland Street side of the new house shows an overhang of 9.7 feet away from the side yard lot line. This overhang is part of the house, which ultimately puts the new house 6 feet closer to the side yard property on Rockland Street than the existing house. In addition, by its sheer size and appearance, this new house will alter the essential character of the locality. From the traditional Portsmouth neighborhood to its proximity to Langdon Park and South Playground, this building will look totally out of place with blatant nonconformity. It'll be a 21st century monstrosity in an early 1900s neighborhood. There are no unnecessary hardships here. Knocking down the existing house is a choice, not a necessity. There are no surprises either. The property is the same size as most of the houses on the lot, as most of the lots on the street. The new owners knew this when they bought the place. Zoning regulations governing the property were also in effect. On site there is an unpaved driveway as well as a single-car garage, both of which could be renovated. These are also choices. This project actually adds to building density, increasing the main building's footprint by 25%, expanding on all sides, increasing the sizes of the porches, the decks, and stairs as well. It may be reaching an increased height in comparison to the existing houses and its neighbors. The proposed cement walls around the perimeter and attached stairways are exceeding the established setbacks on all sides. All of this adds to the resulting oversized structure adjacent to the park and detracts from the spirit and character of the neighborhood. As far as occupancy density is concerned, a single family can hold just as many, if not more people than a duplex. For many years, while I was growing up, there were only 2 women living at 9/11 Kent Street, each one in one side of the house. Each had one side of the house. Commercial property zoning from faraway New Hampshire towns should have no bearing or relevance here, attempting to push through a zoning case in a compact residential area of Portsmouth. Zoning ordinances in place are reasonable, not arbitrary. They are meant to protect their neighborhoods. The new homeowners and their agents apparently do not believe this and seem to feel that the rules do not apply to them. There's been a lot of remodeling and construction in the neighborhood in recent years. Everyone has done well to make their home fit in with the neighborhood, but not the one being proposed here. It looks nothing like any house for blocks around, apart from its general shape. Virtually every wooden house in the area, whether old or new, has tasteful traditional clapboards, shingles, or other horizontal siding appropriate to the character of the long-established neighborhood in which it is located. But not this one. The proposed new home with its horrid T111 vertical siding looks like an ugly modern beach house built along the shores of Rye or Hampton. It even has a cement seawall boxing it off from the rest of the neighborhood. The proposed new home design does not fit in with the spirit or character of the neighborhood whatsoever. It's been said that building an expensive house in a neighborhood increases the value of surrounding properties. But if it is an unattractive house, I don't believe that holds true. Not from my viewpoint or from the park either, for that matter. Having an ugly house built on a street can negatively affect the value and the views of the surrounding properties. Cost does not even seem to be a major issue in the overall scope of this project. The neighborhood was laid out in 1899. Most every lot on the block is 5,000 square feet, 50 feet by 100 feet. Some on the next block are even smaller, and there is a house on almost every one of them. To refer to any of these lots as substandard is actually insulting. The homeowners knew the size of this property before they bought it and the lot line setbacks that came with it. There are no unexpected surprises or hardship here. A good-sized house has been on the property at 9 Kent Street for at least 115 years. And if necessary, an attractive new house would fit on the footprint of the existing structure. Or just renovate the existing structure.
Excuse me.
Yes.
Time up.
One more sentence. A lot of big ideas are being proposed for 9 Kent Street, maybe too big of ideas. Is this the wrong design proposed for the property, or is it the wrong property for the design proposed? Thank you.
Thank you. Is there anyone else to speak in opposition?
Good afternoon, Madam Chair and board members. I'm Jim Lee, 520 Sagamore Avenue. So this has to be one of the most ambitious applications I've ever heard come before this board. This application not only wants to redo the house, they want to redo the whole lot. So I think what I've seen proposed here would definitely alter the essential character of the neighborhood. I'm also kind of troubled by the zero lot line here. I know in years past, this board has been extremely reluctant to grant zero lot line anything. If you recall the famous case of the tree house about 2 years ago, where a 10-year-old kid had a tree house that was on a zero lot line, and that application was denied also. So based on that, my summation of this application is that dog won't hunt. So I would urge you to deny this application. Thank you.
Thank you. Anyone else to speak in opposition?
Good evening. My name is Barbara Adams. I live at 75 Kent Street. I do appreciate your time staying out late tonight. I want to start by just emphasizing 2 of the 7 variance requests, which I hope will be denied. First, doubling the size of the dwelling unit from 2,500 square feet to 5,000 square feet. I know they've explained that part of that is a patio. I have some questions. A patio raised 24 inches of this special surface seems like kind of building coverage. Anyway, and along his second thing I want to emphasize is connected, and that is just to increase the building coverage on the lot from 35% to 53%. Again, that's related to the patio, but I think it does indeed seem like coverage. Secondly, I'd like to quote the Portsmouth Master Plan, which says, the city has embraced the use of historic district zoning and more recently of character-based zoning to ensure compatibility of new development with historic areas of the city. We are not in the historic district. We're just on the outside edge. But we are a historic area, as you've heard from Cliff describing the houses in Kent Street were all built in the 1900s, starting in 1902. They are traditional in size and shape and style. The architecture of this proposed project is a considerably larger 4-story modern California-style building with vertical siding and metal roof, and again, what's been mentioned, the surrounding 300 feet of retaining cement walls. This architecture is out of proportion and it is not compatible with the neighborhood. And I believe it would alter the essential character of our little Kent Street. And finally, just a notice was mentioned earlier tonight. You may have seen yesterday there was a full-page article in the Portsmouth Herald about the housing shortage in New Hampshire. Given the current desperate need for affordable housing in Portsmouth, I believe this project removes the building of affordable housing in a 2-family house and proposes to replace it with a twice the size 1-family house and a pool and a pergola. The applicant claims this project would decrease density and, if denied, would create an unnecessary hardship. I'm not sure about it decreasing density, but I do see that it's decreasing affordable housing. And lastly, I do not see that it's been shown that there is any hardship involved in denying these variances. Thanks for listening.
Thank you.
Madam Chairman, members of the board, my name is Matt Beebe. I live at 81 Lincoln Ave. I'm a builder and building designer. A lot of the things that I had written down have been covered, so I don't want to be redundant, and I know it's late and you've spent a lot of time considering multiple applications tonight. So I'd just like to say, I think when you have a lot that the proposal is to demolish the existing house and start from scratch, there's an obligation to try to make the property more conforming. And in this case, what we have is a existing non-conforming building on a non-conforming lot, and the application is proposing to make it more non-conforming. That's certainly not within the spirit of the ordinance. And I think also that reflects the fact that there's really no hardship here as well, because you're starting with a clean slate. You've got an empty palette. You're taking down an existing structure, and you've got an empty lot with which to design on. And I think, again, there's an obligation for the design team to try to find a way to make it more conforming, even if you can't make it completely conforming, to get it further away from the lot lines in every direction, and to do what you can to help that new structure fit within the considerations that are allowed by the zoning ordinance. So for that reason, I would respectfully ask that you deny this. Thank you.
Thank you. Is there anyone else to speak in opposition?
Hi, Sue Polidura, Middle Street. I am not in a butter, but I do walk around that area a lot. And this is a very modern, for the pictures I've seen, a very modern looking structure in a very old neighborhood. So it looks to me like it's too big. It looks more appropriate for, I don't know, if you were in a more modern development, I guess it would fit, but it is not. So I would ask you that you please review this application very carefully. It doesn't look like it's within the character. It looks like all of the other neighbors have spent a lot of time to make sure that their homes fit, and this one here doesn't seem to fit. So I'm just asking, please review this carefully. Thank you.
Okay, thank you.
Esther Kennedy, 41 Pickering Ave, and I think one of the councilmen asked for people that don't necessarily live in the area to also chime in because it's the Portsmouth. And I do want to remind, it's not just your zoning laws, it's all our zoning laws that was stated by the applicant. I'm reading this on behalf of Attorney Duncan Mahalan. He asked me to read it. I said I would, and I've shortened it because of time. Sometimes it's difficult to draw the line between property rights and your neighbor's property rights. The question can fairly be asked, how do we draw the line between where your property rights end and your neighbor's property rights begin? That's what zoning is and does. It's a zoning ordinance that draws a line between where your rights and where your neighbor's rights begin. It draws that line and imposes setback requirements which require that all the buildings on your property be a certain number of feet away from your property's boundary, and that your neighbor's buildings must be a certain number of feet away from his property boundary, so that there is an adequate air, light, space between buildings, which is one of the express goals of our master plan. It draws that line by imposing building coverage limitations so the properties will not become overcrowded, and so there will be sufficient light, air, and space between the property, these buildings and properties. And drawing that line by imposing height limitations on buildings, that your building or buildings will not cast shadows over your neighbor's property, and so the building themselves will not become too massive, leading to overcrowding. But that's what our zoning is. You simply don't get to do whatever you want, and you don't always end up getting what you want. And if an applicant, all that you have to offer is that you can't do what you want to do if you have to comply with the requirements of a zoning ordinance, then is not entitled to any variance. I just lost my place, so I'm going to stop. I really believe that the applicant has not shown here that they meet the criteria of asking for these variances. I think we've heard from the neighbors, they've done a nice job in explaining, but we all have to ask what the hardship is. And is it really important to build something that takes 54% of your lot coverage? And I don't think so. Portsmouth is Portsmouth. We all moved into our spots. Some of us would like to change where we moved, but we realized we can't, and we knew that when we moved there. And I would just ask you to keep that in mind when you move into a home and when you buy something. Hopefully you've done your due diligence in understanding what that place can offer and what changes you can make. And I'm sad to hear that these individuals bought a home and it doesn't seem like they understood our zoning regulations. And again, there are zoning regulations. Thank you.
Thank you.
Petra Huda, 288 South Street. I don't live there. Right next, I'm not in a butter, but I walk past this house just about every day.
I can tell you, I have looked from one side, the other side, and the other side, and I cannot fathom how they're going to get all this stuff in this spot. To go from 25% to 53% coverage should be a definite clue to this board that we're having trouble with going and actually going to our ordinances here. When somebody asks for 7 variances, I'm not going to go through all this stuff because I think all the neighbors did a very good job at telling you how it would affect them, how it would affect the neighborhood, and that there is no hardship here. And as everybody else said, when you buy in Portsmouth, you need to do your research and see what neighborhood you belong in. And I ask you to deny this based on the extent of what they want to do here. Thank you.
Okay, thank you. Is there anyone else to speak in opposition?
Catherine Eric Killian, 18 Kent Street. There are 12 houses on Kent Street, one of which we're talking about tonight, and 8 of these houses do not want this. Thank you.
Okay, thank you. Is there anyone else to speak in opposition?
8 houses.
Is there anyone else to speak to, for, or against this petition?
Thank you. This is unfolded a little differently than usual, because usually I'm going through my requirements for the variance before the neighbors state their opposition or objections. So I'm kind of caught between going through my requirements and responding to the comments of the neighbors. So I'm going to try to do the former first, just a little of it. One, I asked the board, I don't know if there's a full understanding of those who have talked about the 53%. I hope the board gets what we were trying to say, is that it's an artificial number. The house is roughly 39%, where 35% is the limit. Mr. Michaelides, who's the nearest neighbor, just a couple of points about his. The existing house is essentially the same distance from the common lot line as the proposed house. There's a little more than about a half a foot, 0.6 of a foot. So stormwater coming off the roof is going to be captured there, as will snow and what have you. There was comments about the driveway taking away public parking on the street. Well, I think it's pretty clear that if they don't have that driveway in the garage, they're going to be parking on the street. So they're going to be taking up a couple of spaces on the street that now they won't. Let's see, 3. So Steph, if you can go to the existing conditions plan, should be at the front of that packet. So you can see there that the front porch and steps are also inside, if you will, in the setback. So if you go two pages down. So there's what we're proposing. The porch is larger, but the effect, it's not something you can't see over or around. So the effect of that front porch, and frankly everything else, the other relief that we need for the walls, which is to aid with drainage, is not going to insult or harm any neighbors' views and those kinds of things. Somebody mentioned that there's never been a stormwater plan done. Well, we're required to do one to document that stormwater. You folks know it, but sometimes the public doesn't. You can't have stormwater leaving the property that's greater in volume or velocity post-construction than pre-construction. That's why a stormwater management plan was done. As you heard, a number of people spoke in favor of this. It's harder to get people to come out supporting things than it is opposing. We also have a number of letters of support. So my take on that is beauty is in the eye of the beholder. This has been described as a modern take on a traditional style New Englander home. We think it does fit in with the neighborhood. We don't think that the look of it is really an issue for you folks. Let's see. Somebody mentioned and then admitted this is not in the historic district, nor is it in a character district. As far as the size of the house, someone said that it's over 5,000. The existing home is 2,700 square feet approximately in living space. The proposed home is 3,900 square feet. So I'll turn to the variance requirements now. The first two are the public interest and the spirit of the ordinance. And we think we highly meet those because the underlying test is will the variances, not what color is the house and all that kind of thing, change the essential character of the locality or threaten the public health, safety, or welfare. Clearly it will not, nor will it diminish surrounding property values. This property is going to be significantly increased. And one thing for Mr. Rayom, John Chagnon corrected me. I fell on my sword about the improving, but the requirement for lot size per dwelling unit is 7,500 square feet. This is a 5,000 square foot lot, so getting rid of one unit does improve that one thing. The other stuff I'll stay on my sword about. We think that this is a very tastefully designed house. As I mentioned, we're talking about essentially on the same location. The walls and what have you is done for drainage purposes, which you'd have to do for almost any house. I also mentioned that a house within the setbacks is going to get longer, is going to look more imposing. Hardship, it's a 5,000 square foot lot. It's got existing drainage issues due to the slope.
You are at your limit. Can you wrap up?
Yes, I can. So there are special conditions. Because of the location of the existing house and the proposed house, there is no reason to apply the strict requirements. And then finally, substantial justice. No benefit to the public that outweighs a hardship to the applicant. This factor is satisfied. This is the general public, not the immediate neighbors. And the public is in no way harmed by this. Some people think it looks good. Some people think it doesn't. That's up to the owners to design what they want. So denial means that they can't build what they want. I think that the property rights, their property rights weigh more heavily than the general public's harm to the general public if these variances are granted. I don't know if there's anything anyone else wants to add, but I did rush through that last part a little bit, but you have it in writing, so.
2, 4, or against?
Against. I just want to clarify a couple things. For the record, our house is 8 feet off the property line. Their house is 6 inches. Their proposed new house, because it's a hardship, is still 6 inches. We talk about the porch. When you look at the site drawing, I think it was Plan C2. Their bump out on their porch of their house extends 3 feet beyond everyone else's sight line. Their porch extends 3 feet out beyond 3 feet beyond anyone else's porch. So when they did the measurements on, there's a little block chart on drawing C2, their site plan. You can look at the distances where they reference, the different distances. So their porch and their house does stick in front than anyone else on the street. Number 3 is they mentioned the fact about it, cantilever. They don't want this floating cantilevered wall like 3 feet above, because they have to do a setback for their foundation because they want to put a French drain in. How do they maintain that French drain? They can't get access to it. They have to dig up our land. So when would you ask to build a new house using your neighbor's land in order to do it 6 inches from your property line? Thank you.
Okay, thank you. Anyone else? 2, 4, or against?
We do have one person online.
Okay, we have someone online.
Barbara Jenny.
Hi, I'm Barbara Jenny from 81 Lincoln Avenue. I live just catty corner at the other end of Kent Street on the corner of Lincoln. And I just want to dispute the applicant's attorney. This project would even affect our sense of light and air, as we have a view of the pond and the park from our corner, even on that opposite end of the street. And I just want to point out that I do take issue with the lawyer using the term essentially multiple times. This is a process where measurements matter, specific measurements matter, and I also take issue with the word in terms of not respecting the intellect of the board or the abutters. And I think we do understand the coverage of the hardscape and the patio, and that everything is raised significantly higher. Thank you.
Okay, thank you. 2 for, against. Okay. Public hearing is over.
Be a new record. I think we need a motion to go past 10 o'clock.
Do I have such a motion to go past 10?
Technically, you don't need it until you start on the next piece of new business. But.
Okay, but yes. Okay. All right.
Make a motion.
No, I guess we don't need it till we start. We'll
Madam
just
Chairman,
do
I
it.
make a motion to extend the meeting beyond 10 o'clock.
Is there a second?
Second.
All in favor?
Aye.
Aye. Opposed? All right.
So I'd like to make a comment, several comments. One is that I think this is a somewhat, I'm a little bit torn on this one, and I will tell you why. I actually, as opposed to most people in the room, I actually like the design of the house. I think it will be an improvement to the area, and I also don't think it's out of keeping with the character of the neighborhood. It's been built over at least a century. The housing styles differ from property to property, and people are not going to build now the way they did 100 years ago. They're going to look different. That's a given. Yeah, I'm sorry.
No.
I thought you were raising your hand. Thought I was saying something particularly stupid and you wanted to interrupt me. So I don't have a problem with that. I don't believe that it would be contrary to the ordinance, the spirit of the ordinance. And I don't see any general loss to the public, so I don't have a problem with 10.233.23. I don't think there's a credible case about diminishing values of the surrounding properties. Where I am having a difficulty is in the hardship of the land forcing the need for these variances. And I think that, just seems to me that almost all of the variants, especially the lot line clearance on the right side, are driven by the desire to have a garage underneath the residence, which causes everything to be raised and more drainage to be put in, and all of these retaining walls and landscaping walls and all that. And I don't think that lack of a subterranean garage is really adequate justification for all of these variances. I don't think that the property offers a hardship that requires a subterranean garage and the resultant placement of the house 6 inches from the right side property line. And I think on that basis, I cannot support the variance.
Thank you.
I will say I'm not going to be supporting this variance request. I do not think that the applicant has persuaded me that there is any hardship with respect to this property, that there's any special conditions that make it exempt from sort of the requirements of the ordinance. I think particularly problematic for me is the elimination of the primary front yard setback from 7 to 0. That really does affect the street scrape, the way that the houses fit in that neighborhood on that street. The building coverage is just a hard no for me, in that I recognize that the applicant has suggested or has argued that it is essentially open space. It is not. It is a structure. Open space has to be free of structure, and it significantly increases the building coverage. And in almost all ways, except for maybe the right front yard setback,
this application actually makes the property more non-conforming, so I will not be supporting it.
Comments? Yes.
Yes.
Mr. Mayo.
Thank you, Madam Chair. Like Mr. Rossi, I am not conflicted on this. I do not see where this can be approved. I think what's going on here is best summarized by the applicants on page 191 of our packet, the 7th page of the applicant's presentation, where it says that the applicant will be greatly harmed by the denial as they will lose the opportunity to redevelop the property as desired. And I do think that the as desired is driving a lot of what's being requested for relief. So many times when we are being asked for relief for a brand new structure, one that can be made fully in compliance with the existing requirements, we at least get some type of argument that, hey, we're improving this, but yes, this is still non-conforming, but not making it any worse. I would say in every single dimension here, the applicant is asking for more relief than what is currently needed for the existing structure in every single way. And there's just nothing, from that balancing test. What is the city getting back from this application? And it's not getting very much. And I fully agree with Ms. Margison. The argument's been made that the 53% coverage isn't a real number because it's actually all this other stuff that we want to have to create our lovely backyard that we want to create. Yet we have held other applicants to the same requirements for wanting a 20-inch high deck that they want off the back of their house, and in times we have not allowed that because of would not satisfy the criteria. So that's just because it's made up of earth and stone does not necessarily make it any less impactful. In fact, I would almost say a little bit more impactful because I think that the neighbors have made a pretty good argument that sort of the rolling hill topography on the back of this property that sort of contributes into the park as a whole has a positive effect from a public perception standpoint that could be negatively affected by what the applicant is asking for. I also think, we've got all of this discussion about, driving piles and cantilevered floors. And all of this is, being driven by, some of the desires again for, as the applicant's technical team has discussed, being the desire for the underground garage, the desire to make it closer, and the fact that we're right along the neighbor's wall is in the topography there is creating this, incredible need for all these structural uniqueness about this project. To me, that's saying more that it's not appropriate rather than, hey, look at all the great engineering feats that we're doing to overcome all of these challenges. I thought the next door neighbor made an outstanding point in discussing that the pitch of the roof is being reoriented from being a side gable to a front gable, which is more impactful from the fact that the property is being asked to be put right up against their property lines. Now, all the rain and potentially snow is going to come down on their property, whereas the current arrangement, it would not do that. And the applicant's own house, the neighbor's own house, does not have that feature. It too is a side gable, not a front gable, so it is not impactful. And as they have pointed out, they are some additional distance away from the property line with their house. And again, light and air. Sometimes we've had the argument, oh, well, we can afford a 0-foot property line because, look, the neighboring house is way far away and the apparent impacts on their house are minimized. We don't have it in this case. In fact, the next door neighbor, their house is also shoved over up against next to the property line. So again, aggravates that, doesn't make it better. So with all of that, I feel this fails several of the criteria, doesn't support the balancing test. As far as the architecture goes, this is not the Historic District Commission. We have no control over the architecture. The applicant is more than welcome to put up a glass box so long as that glass box fully complies with all the requirements of setbacks and total square coverage. I don't care what the building looks like. What I do care is what they're asking for relief from this board and our criteria, which I don't think that they meet in any way. That's my concerns. Thank you.
Is anybody ready to make a motion? I feel like we've had a lot of words out here, and we might want to move forward.
Sounds like Mr. Rayum can sail right into a motion.
If desired, Madam Chair, I will move to deny the applicant's requests.
Okay, is there a second?
Second.
Okay, thank you, Mr. Mantle. Would you again tell us about your...
Yeah, so, I mean, it only has to fail on one of the criteria. I do think that it fails on a few of them. One is granting the variance would observe the spirit of the ordinance. There's a lot of relief that's being asked for here. That what the ordinance is trying to accomplish with those restrictions on this lot are being directly impacted. Neighboring the neighboring properties, I think, are negatively affected from a light and air standpoint, from a imposition of water runoff standpoint, from a complexity of design. I think the applicant, the next door neighbors, also made out some arguments that maybe the maintainability of this complicated design up against their property line will cause future issues. So I think all the things that the ordinance is trying to avoid are being impacted here. We don't normally mention substantial justice, but again, I do think that the general public has a concern here with a balance of what are we getting versus what are we giving up. It has been noted that this structure is in a very prominent location. I think some of the things that are being asked for are potentially negatively impacting some of what the public would be looking for in that prominent location. Again, architectural things aside, I'm more worried with positioning and impacts to the total amount of coverage that is taking place and is being asked for with this application. And then lastly, the hardship. Again, there's nothing, this is a brand new construction. The applicant has an opportunity to construct some type of new structure that could be, in my opinion, in full compliance, or at the very least requiring some kind of lesser relief that could come in before this board. And there's no other characteristics about this property. In fact, all the characteristics that I see are sort of like negative hardship, where I think there are things that make the requested relief even more egregious rather than being something that they can point to say, look, here's a unique aspect to our property that makes it so that we should be granted something that no one else would necessarily get. So with that, I recommend disapproval.
Does the second have anything to add?
Yeah, I agree with Mr. Rome said. I mean, for me, they're asking for 7 variances. Now, we've seen requests of that much, but this is brand new construction. Now, 2 of them you can't change, 5,000, 5,000. All the others can get better, whereas all the others get worse. And that doesn't make any sense on new construction. That's why I support the motion.
Is there further discussion before we go to a vote? And Jody, Ms. Record, you are the voter on this. Okay. No? If not, I will call for a vote. Ms. Record?
Votes
We're
to
voting.
deny.
Yes. Okay, sorry. Yes vote is to deny. Thank you. Mr. Mann?
Yes.
Ms. Margison?
Yes.
Mr. Mattson?
Yes.
Mr. Rossi?
Yes.
Mr. Raham?
Yes.
And the chair votes yes. So you are denied.
Can we take a break?
Would you like to be
No?
really?
No, we gotta get down. Yeah, it's
Okay.
too late.
Yeah, I actually like the design too, but it just does not at all fit a lot, yeah.
If they take the design.
It's actually a great spot too. 'Cause
One of them, I
it's just
just went over maybe this package.
way too,
Okay, the next,
particularly the 6-inch setback.
we have to.
We have to.
Yeah,
We've got no choice.
let's go.
Unless we decide.
No, this next one will be easier.
Let's go.
I think. And what else?
Really?
Yeah.
You dare to say that out loud?
I don't know.
All right.
Oh my God, we lost our audience.
The next item of business is the request of Angela Davis and Catherine Nolte, owners, for property located at 276 Aldridge Road, whereas relief is needed to construct a 5-foot by 4-foot landing, which requires the following. 1. Variance from section 10.521 to allow A, 3-foot secondary front yard where 30 is required, and B, 35% building coverage where 20% is required. 2. Variance from section 10.321 to allow a nonconforming building or structure to be extended, reconstructed, or enlarged without conforming to the requirements of the ordinance. Said property is located on Assessor Map 116, Lot 14, and lies within the Single Residence B District. Who's here to speak to this petition?
Hi, I'm Kate. Thank you for your time and thank you for your patience during the application process. We were doing that as homeowners ourselves. We are proposing the construction of new stairs with a landing to access the side of our home. This construction will consist of 6 stairs from the existing patio to a 5x4 landing to the entrance of the side of our home. The reason for this request is to increase the landing larger than the 3x3 foot, is to attach the actual support beams to the existing foundation wall. If we don't have this variance, basically those posts would be in line with the passage door on the garage level, creating a safety issue there. So that's why we're asking for this variance. I can move on to the variance criteria if you like.
Please.
The variance will not be contrary to the public interest. The side stairs and landing would not impede on the abutting neighbors. Also would not alter the character of the neighborhood. To the spirit of the ordinance will be observed. The new side stairs and landing will not threaten the health and safety of the general public and would provide safe access to the main entry of our corner house, whereas parking is in that main driveway on the side of our house. Substantial justice will be done because the loss of the applicant would outweigh any gain to the general public. The values of the surrounding properties will not be diminished. This would be an improvement to the home's overall curb appeal, as well as welcoming main entrance as we are the corner home again. Literal enforcement of the provisions of the ordinance would result in unnecessary hardship, again, just basically because of the safety issue with us being a corner home again.
Okay, thank you. Does anybody have any questions? Mr. Ram?
Thank you, Madam Chair. So I guess I'm trying to understand a little bit better what's going on with your house. So it looks like you're doing a major renovation project. Is that what I'm to understand?
It's not major. We did have a stairwell that would go up between where the kitchen and the living area is on this first level floor plan. We eliminated those stairs. We did have a permit in to create a stairwell on the exterior of the home, or I shouldn't say the exterior wall of the home, but come inside where the garage is. And due to the way that the support beams are in the garage, we decided to go ahead and make a 36 by 36 inch landing to go to the patio. So we tried to do that 36 by 36, and due to the way that it's positioned over the passage door on the garage level, we had to expand it by 1 foot in one direction and 2 feet by the other, so that those support beams could go into the foundation wall.
Okay, so the external staircase was always part of your plan?
It wasn't.
Okay. So previously you had only an internal staircase? I guess
Yes.
I apologize.
Yes.
Okay. So this whole need for an external staircase is something brand new that is driven by the fact that your original plan for an internal one doesn't work.
Correct. We would require, I believe it was 6 different LVLs and reconstruction of the garage in order to do so.
Okay. Just one item, just in your first page of your discussion you have in here, the reason for our request is to increase the landing larger than the maximum 36-foot requirement. I'm presuming that's the 36-inch requirement?
Yep.
Okay. But we call that the This is Spinal Tap effect. Right? We've seen that movie. Okay. And then you talk about an easement on the couple pages down. It's page. I'm not getting the page numbers right now.
It's page
310.
Like, yeah.
Yeah, 310. It says a large easement, but really that's just a city-owned right-of-way. Is that what that is?
I believe that's the case, yes.
Okay.
That's something that we've maintained over the last 5 years that we've lived there.
Yeah.
So yeah, we'd like you to take that in consideration when giving us this variance.
Okay. Yeah, we just want to be careful about use. I'll let the lawyers weigh in on it, but the term easement has a very legal sense to it. But really, it's just simply a part of the right of way of what the city owns through that area as part of Sewell Road. Okay, that's all I have. Thank you.
Okay, other questions for the applicant? No? Okay, thank you.
Thank you.
Oh, did you have?
No, I'm giggling a little bit because I too, with all the applications we had, I really struggled with this one, understanding it. So I appreciate Mr. Williams because I really did have a hard time understanding it. So thank you, David.
My apologies. Thank you.
No. Is there anyone here to speak in favor of this petition? Is there anyone here to speak in opposition to this petition? Is there anyone here to speak to, for, or against this petition? Okay. Then the public hearing is closed, and it is back to us.
I'd like to make a motion to approve the variance as presented and advertised.
Is there a second?
Second.
Okay. Tell us about it.
10.2, 3321 and .22 to be taken together. There is no public interest that militates against the construction of this landing. Therefore, those criteria together are met. Granting the variance would do substantial justice. There is no loss to the public by constructing this that would outweigh the benefit. Let's see. That would outweigh the benefit to the property owner by constructing this, so that criterion is also met. Granting the variance would not diminish the values of the surrounding properties. In a visual inspection of the property, it's kind of even hard to see it from the street because of the shrubberies that are planted, and it's in a very unobtrusive location, so there is no effect on the surrounding properties. And because of those reasons, literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. Basically, when this is completed, it will be consistent with the character of the surrounding properties, and therefore denying this would be pointless. So.
Thank you. Does the second have anything to add?
Yeah, I just add that the unusually large right-of-way on that side of the street that the landing will go on is a unique condition of this property, and it also lessens the effective amount of relief being asked for specifically for this variance. So for those reasons, I move to grant it.
Okay.
Or second.
Thank you. Any other comments, discussion? Okay, and Ms. Geffert, you are voting on this. So, a yes vote is a vote to approve. Ms. Geffert?
Yes.
Mr. Mantle?
Yes.
Ms. Margison?
Yes.
Mr. Mattson?
Yes.
Mr. Rossi?
Yes.
Mr. Rayum?
Yes.
And the chair votes yes also. Thank you for waiting so.
Thank you. Yes. Sorry about that.
Okay, and here we are. So the next item of business is
There's
the
our city staff
petition
in the back.
of Salem Manufactured Homes LLC for appeal of an administrative decision to require a variance for the expansion of a nonconforming structure in accordance with Section 10.321 of the zoning ordinance for property located at 210 Oriental Gardens. Said property is located on Assessor Map 215, Lot 9-21, and lies within the Gateway Corridor District.
Thank you, Madam Chair, members of the board. My name is John Kazinovich, the attorney for Salem Manufactured Homes. With me is Glenn Gidley of Salem Manufactured Homes.
Can I start with a question? I'm sorry. So, Mr. Kazimowicz, I just want to know exactly, so you're representing the manufactured homes. Who are the homeowners? Okay. And are they authorizing you to take this appeal in their name? Normally, we get appeals from the homeowners or somebody authorized by them, but you sell manufactured homes.
We were the applicant for the building permit that was denied.
But the homeowners are here and they're authorizing you to?
Yes.
Okay.
Yes.
Okay. Thank you.
Okay, may I
Go ahead.
start? Okay, good. This concerns the home at 210 Oriental Gardens. The proposal is to replace a manufactured home with a similar one. The replacement is 148 square feet larger. That 148 square feet is not just living area, but is also the stairs, external structures to the mobile home. The mobile home is no extra bedrooms in there. It is just slightly larger. Part of the reason for it being larger, and I just learned this today, the mobile home or manufactured home that's replacing was built in the 60s. Back then, the standard width was 10 feet. You can't get a 10-foot wide mobile home today, or manufactured home. They are either 12 or 14 feet wide. And this is usually forced by code requirements as to minimum size of certain rooms, certain bedrooms. So a slight increase in size is just for code compliance. It is not huge homes going on there. The proposed home is going to be 600 square feet. We're talking about a very tiny structure. The proposed home has absolutely no change on the mobile home park. It doesn't change roadways, it doesn't change the character of the park, doesn't change the feel of the park. Basically, it changes a little bit of open space, lawn gets eaten up this way. It does not change significantly impervious surface. The stairs proposed are wooden stairs, so there will be slats. If they're not wooden, they're composite, but water will drain through, will have no impact. Won't have any impact on occupancy, won't have an impact on traffic, won't have any impact on all of the environmental concerns that were set out in the city's response, which was dated today and given to me at the hearing. Thus, since there is no change on the park remains unaffected and there's no expansion of use. Now, mobile home parks have mobile homes, which means this was always a conforming structure. And we're substituting with something very similar. For the planning director to fail to recognize this is legal error and an abuse of discretion. I would note that we fully conform with the manufactured housing setbacks. We are not seeking any relief for larger setbacks. The components, again, in the opposition I received today, talks about a mobile home park being comprised of components. Well, if you enlarge one component, you're making one smaller. So there is no expansion of use, of the nature. It's a substitution or an alteration. The opposition today focuses on an alteration being an expansion. There is no legal precedent for characterizing an alteration of a component of a use as an expansion of a use. Historically, the planning department has allowed replacement manufactured housing having up to 25% more area, employing a rule of reason. This is important for several reasons. First, in the appeal, I cite the case law saying you don't lightly deviate from the past practice of an agency in the way it interprets a statute. Here, out of the blue, there is a complete role reversal or complete enforcement reversal. I note in particular that there have been 2 replacements at this very park which have allowed larger homes without going through a variance. And that has been common throughout Portsmouth. We wondered why this was going on, which I will get to in a moment. The planning director never addressed RSA 674-19, a copy of which is attached to the appeal, for zoning to even apply. The change would need to be substantial. A change of the magnitude here that has no effect is not substantial. There are criteria established in case law, and it's whether the nature of the nonconformance and it reflects whether or not the change still will reflect or conflict with the nonconforming use, whether the issue is merely a different manner of utilizing the same use, which is exactly what we have here. It's not substantial when you're being a typical manufactured home in a park consistent with everyone else. I do want to talk, it's not a legal reason, but it's important because affordable housing is important. And if we have to go through variances for each unit, we will drive up the cost. I mean, if through this appeal we get some clarity that goes forward, it will significantly save costs. I found it almost amusing that the planning director in the opposition today says, in fact, larger mobile homes will likely cost more, thus driving up the value of homes and the cost to the residents to live in the park. I hate to say he was direly misinformed when he wrote that. In this instance, in this park, it is the mobile home owner who chooses the model home they want, the mobile home they want. So the size and cost are totally within control and chosen by the homeowner. And there's a standard lot or space rental fee. So there's zero financial impact on the homeowner. Basically, the opposition's funny because in the end, it supports us. It says the initial expansion of one unit, if allowed, may not noticeably change the character, operation, or feel of the park. Exactly our point. But what's it mean here? It means the planning director has done something unlawful and is asking you to do the same. Right now before you is denial of a building permit for one manufactured house that beyond doubt does not do anything to affect this mobile home park. But instead, again in the opposition, the truth finally comes out as to why there's this sudden reversal and denial. The planning department wants the benefit of an overall site plan so that there could be sewage studies, there could be looking at infrastructure capacity for water, drainage studies. This board is not authorized to order those kind of studies. And to the extent it endorses the planning director, it is going far beyond its purview allowed in law. The planning director in his opposition is just speculating that there will be all of this rash of changing to theoretically much larger manufactured units. In the last 5 years at this park, 2 homes in total have been replaced. This is not a situation of wholesale replacement. This is the speculation of the planning director for homes that maybe can be done. I'm not saying it would be a bad thing if the Portsmouth ordinance had a trigger for this kind of review, or if there were a certain minimum number of homes, if they were all being replaced at the same time. But nothing authorizes this kind of review being triggered by a single replacement home. And to allow those factors is not to consider the record. To allow factors such as saying impervious is going to increase without knowing how much, because that's never pointed out in the director's decision. There's no factual basis or factual predicate for anything that has been done by denial of the permit or the planning director saying there's a variance. And it's also very misleading to this board. Going through the variance steps would not get these water, and so every single concern that the planning director has identified in opposition is totally inappropriate for considering in the context of a variance. I think that this is a first step to try and get a different kind of review, but it's the wrong way of getting it done. This is a de minimis replacement situation. It's a continuation of an existing mobile home park usage, and it would be against the statute because it is not a substantial change to prohibit it.
Thank you. Other
Thank you.
questions? Yes.
So, Attorney Kucinich, I'll be honest to the planning director, I'm not going to take his memo to us today into account when deciding this appeal, because I feel like the record is what was before us today in the package. However, the section in the zoning ordinance is very clear, 10.321, a lawful non-conforming building or structure may continue and be maintained or repaired, but may not be extended, reconstructed, or enlarged unless such extension, reconstruction, or enlargement conforms to all the regulations of the district in which it is located. This is the mobile home park, the manufactured housing park is a lawful non-conforming use. The zoning itself has changed to office research. So therefore, anything that happens within this park needs to have a variance, because the underlying zoning, it's non-conforming with the current zoning. Now, to get to my question, the RSA 674-19, with all due respect, you focus on the part that's after the or. It's in a manner which is substantially different from the use to which it was put, from the use to which it was put before alteration. And the case law that you cite is dependent on that part. However, the part before that says it shall apply to any alteration of a building for use for a purpose. So the state law itself says that the zoning ordinance does apply to the alteration of a building, and that alteration is reflected in 10.321.
Except it doesn't apply if it is not substantial. The statute first affirms applicability and then carves out exceptions.
I don't agree. I think it applies to both of those, the enlargement or the substantially different use from which it was beforehand.
However, the use of the mobile home park being there that's grandfathered, which means mobile homes within the park can be considered conforming. They are not separate structures. They're components of a mobile home park.
There is no grandfathering in zoning ordinances.
Do you have further questions?
debate?
Oh, I'm sorry.
That's it.
Are there other questions? Yeah, please. Yeah.
Thank you. Question, I'm not sure how much you know and understand about the history of the zoning for this parcel, but do you know why it's zoned office research as opposed to garden apartment mobile home? Was it ever garden apartment mobile home?
I did not do the look into the history of this zoning.
Okay. Thank you.
Mr. Mattson.
Yeah, I guess I would like to ask, so we're talking about both non-conforming uses and non-conforming structures. You're saying it's a grandfather non-conforming use, and so the non-conforming structures, or you're basically saying that they're conforming structures. So you're saying that they could change all the structures in there in the mobile home park, and there wouldn't be a need for a variance?
That's correct.
Okay.
Because when you take the park as a whole, if you change something in one direction, if you expand something in one direction, you reduce another section of it. It kind of is a self-balancing thing.
I understand that. I guess it's the land isn't a structure, and the you're taking issue with the planning director referencing 10.321, which is about the non-conforming structure, and you're saying that it's actually a conforming structure, but the use of a mobile home park with mobile homes.
That's right.
Is you're admitting that that's non-conforming. It's just that that was grandfathered.
Yes. In other words, you focus on the park as a whole and whether or not this causes somehow an expansion of the use as a park, and it doesn't.
Okay.
Are you done, Mr. Metzen? Okay. Mr. Rossi.
You make reference to the section of our zoning ordinance 10.816 for dimensional standards in manufactured housing park areas.
Yes.
I presume that you're not contending that if a new structure were to be modified or replaced, if a structure were to be replaced with a new structure that did not meet these standards, that too would be something that would be of no concern to this board?
No, I think that would be a valid concern, and if we were not going to meet the dimensional requirements for manufactured housing, we would definitely need a variance for that.
So you're asserting that the new structure being placed here is in full conformance with 10.816?
Yes.
Including separation between units and all of that stuff?
Yes. Yes.
Because in your Malthusian explanation of you give some, you take some, I mean, the part that would be most likely sacrificed is the separation, which would be not good because it could be out of conformance. But
No.
you're saying it's not.
No,
Okay.
we totally conform there. I think that would be a different issue and different concern entirely.
Thank you.
Did you have a question?
No, I can wait till we discuss.
Well, you're not the alternate on this one, remember, so you will not be voting.
Okay.
You may ask a question, though.
All right. Would it be fair to say, if I could summarize, that your argument is this, that the current statute permits, and I'm talking about 674-19, permits a modest change to a non-conforming use so long as it is not substantial without seeking a variance, and you are challenging the action of our planning director because you feel it was in error for the planning director to conclude that the change of 148 feet was substantial. Is that a correct summary of your position?
Yes.
And one other question.
Okay. Well, that's my position as far as the statutory interpretation of that portion of the argument.
And just the other piece that you're saying, which is, I think, harder to swallow, is that just because the entire park is a non-conforming use, certain things are permitted within it, and I think you've lost us there because you said not everything is permitted there, but then on the other hand, some things are permitted there, and I think that that's a muddy argument, but you stand by it, is my question?
Yes.
Okay, good. That's it. That's good.
Okay.
So there you know.
Mr. Mantle?
Okay. Attorney Kucinich, you stated that the replacement mobile home is 600 square feet, correct?
Yes.
Okay. What are the dimensions?
I may need Glenn to get up here for dimensions.
Glenn Gidley for the applicant. The dimensions of the proposed home were 20 by 30, approximately.
20 by 30?
Correct.
Do you have another question?
What? Did you say 20 by 30?
20 by 30.
20
by 30.
20 feet wide, 30 feet long for
600.
approximately
Okay.
600
Okay.
square feet.
Okay. Doesn't seem like a 20-foot wide would be mobile, but
It would
But
come in
that's
two
not-
pieces.
Okay. Now, what was the structure before?
10 by 50.
Okay, thank you.
I guess what I'm not getting is why 10.321 applies to other structures in town, but not to mobile homes. Every building in this town is in a neighborhood. It is defined by its neighborhood. The zoning may have changed, it may not have changed, but when it's too close to a lot line, regardless of what year it was built or how many times it needs to come to us for a variance. Why should mobile homes in parks not have to do that?
Because the fact that the park exists mean the mobile homes can be considered conforming.
So so how is that different than another development that builds, let's say, cookie cutter homes? And one of them wants to change. They don't need approval because there's an overlord there that says they can do that? Now, this is a serious question. I don't know why you're different.
We're different because it is a grandfathered use of an overall structure. And if you couldn't have changes to the components of that use, you'd effectively be denying the fact that it exists as a mobile home park.
I'm not sure I get that, but I'll.
Right, it's a muddy argument.
Yeah. Why isn't it true of every zoning?
Yeah, so could I just clarify, are you basically saying there's no difference between the use and the structure?
That's correct. In this instance, because it is a park which is a very unique creature under the zoning law, it's not like a subdivision.
But so if you're saying there's no difference between the use and the structure, and you're admitting it's a non-conforming use, isn't it also a non-conforming structure?
I haven't admitted it's a non-conforming use.
You said it's a grandfathered use that is no longer...
The mobile home park, not the mobile home itself. I'm focusing on the park as opposed to the structure.
But could you focus on the structure, the park within this Portsmouth zoning ordinance? It's a mobile manufactured housing park in an office research district.
Yes, and it's allowed to exist as a mobile home or manufactured home park.
It's a non-conforming use. It's non-conforming to the district. So any time that you have to make an alteration, you have to come before us because it is non-conforming.
May I just, and I don't understand what grandfathered means. I mean, when an area changes zoning, no one takes the houses away and starts over. Is that since it's grandfathered?
Yes.
Yes, and those structures need to come to us. They need to come for variances. They don't come for variances. Sometimes they do.
If we get to the actual debate portion of our
Okay.
of our meeting here, I have my own thoughts on this. But
Okay, I think that we're trying to figure it out as well as we can.
Mhm.
Are there other questions?
Well, what statutory ordinance, case law authority do you have for something being grandfathered?
In the context of manufactured housing or mobile homes, I don't have any. I looked.
Thank you.
Are there further questions? If not, would you?
Madam Chairman, Chair Lady, I would like to make sure that the opposition get as part of the record, because I think it is very important to the consideration of this matter.
Okay, I hear you.
Thank you.
Mr. Ram?
are we done with the public hearing?
Are you, would you like to speak?
Yes.
Good evening, Madam Chair, members of Board of Adjustment. I'm not here as an attorney. I'm just here to defend or explain my decision as administrative official, the Director of Planning and Sustainability. I did deny the expansion of a mobile home, which expanded by 148 feet. As you all know, so I'll go through the facts a little bit, but I have some more context. This is an office research district. Mobile homes are a prohibited use. Therefore, all the homes and the use is a lawful pre-existing non-conforming use. So those non-conforming uses may not be enlarged or extended, was my interpretation. The larger mobile homes will create a larger footprint area, reducing the open space, increasing the coverage within the mobile home park. These mobile homes are an essential component or element of the park. Therefore, if the homes are expanded, the use is expanded. So that was my rationale. Just like if you had a non-conforming industrial building in a residential zone that wanted to expand, it would need a variance, similar to that. So the proposed expansion, if allowed, it might not create a noticeable change. It isn't a very big addition. But if it's allowed, then there's no stopping the next one, which could be bigger. There's no notice that happens when these happen to expand in the park, and it could impact the park residents. With no restrictions or controls on the size, the look and feel and the operation of the park will change. The use changes. The larger the homes, the cost for the homes will go up. That's a potential scenario. I don't know that that will happen, but that's something that I considered in making this decision. The amount of stormwater on the site is going to change if the homes get bigger because there's more impervious surface. There's no requirement to reduce the impervious surface with the expansion of a mobile home, so they will get bigger. There's no control on that. All the things that change impact the residents that live in the mobile home park. So therefore, the approach was to require that a variance be required when a mobile home is expanded in this zone. So that was what my thinking was in doing that. And I thought if they have to get a variance, then a notice will be sent out. The residents will know what's happening. They can ask questions. If the parking changes, they'll understand it. Why? They'll understand why. They'll have a chance to come speak to it. And so that's really the reasons I made the decision. The one other point I'd make is we did some searching this afternoon and found that, yes, we did allow for replacement of mobile homes in kind with the building permit in 2019. However, in 2007, a variance was required for an in-kind replacement of a mobile home. We aren't really talking about that kind of interpretation. And then 3 variances for increases in size were required in 2004, 2008, and 2015. So the record isn't clear on exactly what the department's done. It's not super consistent. I think it'd be nice to have consistency, and I'd like to do that going forward, and this will help that approach if we can come to a conclusion on this. So that's my thinking on how we got here. If there's questions, I can take them.
Thank you, Madam Chair. So if this property was zoned garden apartment mobile home,
yes,
would an increase in the size of any one of the units have to come before anyone?
We look at it occasionally on a mobile home park to make sure that the coverage and the area doesn't get exceeded, but Hillcrest Estates is the best example, and they're far from that, so they basically know is the short answer.
Every other mobile home park that is in fact zoned garden apartment mobile home, so long as they're complying with 10.816 and the dimensional standards in our zoning ordinance, they would not have to come before you for one-for-one replacement.
They could switch it out, yes.
Okay. Which is the vast majority of our mobile home lots here in the city where mobile homes exist. I think this one and one other one is the only one I can think of that aren't in.
I think that's true.
Yeah,
certainly the number of homes.
Okay.
Yep.
So your argument is that the use, because the use is non-conforming, that now applies to the structure that's on the use. But why would our zoning ordinance separate those two things out so that you have 10.321 that talks to a lawful non-conforming building or structure and a completely separate section, 10.331, talking to a lawful non-conforming use which may continue, i.e. it's grandfathered, but may not be extended, enlarged, or changed except in conformity with this ordinance. So our ordinance talks about it in two separate places, yet your argument is the two things are actually merged together, and I'm trying to understand that.
So the way I look at it, or the way I looked at it in making that decision, was that the use is actually changing because the size of the mobile home is changing. So that's essentially, it's a component of the use is the homes in that park. They're elements of the park. Without the homes, it wouldn't be a mobile home park, it would be a park. So the mobile homes are there. If the mobile homes get bigger, then the size of the mobile homes in the park get bigger. Use changes. Say, for instance, one is a one-bedroom and they make it a two-bedroom. Well, there'll be another bedroom for people to live in that mobile home park. The use is different.
But again, if it was own garden apartment mobile home, those are not anything that you would have control or concern over.
The use isn't changing in that case because it's a garden apartment mobile home with a conforming, the lot would be the issue there.
Okay.
But the lawful pre-existing non-conforming is what triggered that decision.
Okay. And, all right, I think that's all I have for questions. Thank you.
So is it your position that when you have a non-conforming mobile home park, any change in an existing structure would tend to be viewed by the planning department as substantial? And so what I'm tying that to is the statute and a couple of the cases. And just to reiterate, statute basically says a non-conforming use shouldn't be expanded or altered unless, and I'm misquoting, but unless that alteration is not substantial without some process. And the general policy of the zoning law is to carefully limit extension or enlargement of a non-conforming use. So I think you're landing there. I think there's also recognized in this state that a pre-existing use that's non-conforming, any change to it doesn't necessarily have to trigger a process, but a substantial change would. And so just getting back to where you're coming in, what you're saying is, look, you've got a non-conforming use, which is the whole park, and any change to a dwelling within that from what was agreed at the time that it was initially created, from the perspective of the department, is substantial. And you may develop criteria that may change that view, but right now that's kind of where you're coming in.
Any change that's involved in expansion. So I guess
Okay.
If the shape changed, but the square footage was the same, I don't know that we would require a variance because it's not expanding, it's the same size.
But you'd hold out, and I'm just coming back to you because perhaps that would crowd things or create, right? I mean, all I'm saying is, as I'm trying to interpret your position, it's if you have a non-conforming use and you're changing something within it,
right?
Your view as the department is that that is substantial, and you may develop interpretive guidance going forward that parses that a bit.
Right.
Okay.
Any other questions?
And I should mention Trevor McCourt is here from our legal department if there's more in-depth legal questions that are needed.
Are there any questions for the law? No.
But I'll be very brief.
Please, yes.
Again, both before the planning director and before this board is a single unit. And I think you just heard the planning director admit his thinking was all about what may happen with other expansions, instead of saying this was a two-bedroom unit, it's staying a two-bedroom unit. There is no substantial change. And here, if the department's position is that any change is substantial, first, I don't think that makes sense. But secondly, take things, suppose they just added a new set of steps outside that which in this instance were 48 square feet. The steps that don't increase the sewer load, they don't increase water use, the whole thing. They don't increase impervious surface. So there are changes. And then also think within zoning how many times you might alter something. For example, you have a porch that's part of the footprint on your house and you screen it in. Technically, that's an alteration to it, but it doesn't change anything from zoning perspective. And finally, I actually like the analogy of the expansion of a use with inside an industrial park building. Think of this as moving an interior wall of the industrial park building rather than bumping outside of it, because I think that's the more appropriate analogy. Thank you.
Okay. What would you like to do?
Are we finished with the?
Is there a public hearing on this?
No.
Is this-
No,
And
it's
the
just an
pants is
appeal.
more
Okay.
Quasi-judicial, yeah.
So I'd just like to make a comment. I mean, I think what the planning department is looking for is some consistent rubric with which to make these sorts of judgments. And it seems, I don't know, maybe I'm not firing on all cylinders because it's late, but it seems pretty straightforward to me. As long as a structure within this mobile home park, and I'm confining my comments to this mobile home park, not a general interpretation of how these various parts of our ordinance and RSA interplay together in other situations. But in this park, which is a non-conforming use in this zone, I think as long as a new structure or replacement structure complies with 10.816, there should be no need for any further action by this board. Full stop.
Thank you, Madam Chair. I agree with Mr. Rossi's fundamental point. I come at it from a slightly different standpoint. As I mentioned, I think we're getting jumbled up here, and the planning department and planning director are getting jumbled up with the concept of uses and the concept of structures. And I do think our ordinance, in my mind, is quite clear. I wish it was super duper perfectly clear. It probably doesn't go up to quite that low, but I think it's clear enough in my mind that when you have a structure, you go to all the dimensional standards and you say, is this structure meeting the dimensional standards that we have in our zoning ordinance? When you have a use, you put the use up against all the requirements. Is that use appropriate for the zone that it is put in through our tables of what's allowed? And then there's some other things that are thrown in there as well, such as distances away from other things for that particular use. We ran into this exact same thing 2 weeks ago, and I kind of warned at that point in time, I said, you know, somebody could challenge this because I thought it was an incorrect interpretation of that case where we had what was a use concern of having a motorcycle dealership business that was in a neighborhood that was incompatible with that. And the board had previously determined that that was an acceptable use for that area. But the applicant came along and said, oh, I want to make my building a little bit bigger. And we suddenly said, well, you're expanding what you're doing, so you have to come before the board. I made the argument at that point in time that didn't make any sense. It really wasn't changing the fundamental impact of that use on the surrounding neighborhood. Now, so I mean, I think our ordinance is clear on that point, and worse yet, I think there's really a fairness issue here that anyone who now has a non-conforming use throughout the city has all this additional concerns about their structure imposed upon them because of that simple fact. So there are dozens, if not hundreds, of uses that aren't allowed by our ordinance that either were approved by this board or were grandfathered in because they were an existing use that may remain in place. But when we say in 10.331 to be extended, enlarged, or changed, in my mind, that is an aspect of the property itself. The property grows in some way, shape, or manner, or and it's not a factor related to what the structure is on it. And as in some of the extreme cases have been brought up here, I mean, you could say that somebody whose house is non-conforming, anything that they want to do to it now becomes a variance because their house, say it's a duplex in a single residence neighborhood, so every single thing that they want to go and do to their house is considered an increase in its duplexness. And now suddenly they are being penalized and have to come before this board, whereas the same identical house that's in a zone that allows duplexes wouldn't have to. There's a fundamental fairness issue there that if we start going down that path, I think we're running into an area that I mean, you could be significantly challenged that you are doing unlawful takings of people's property rights. So in my mind, I appreciate what the planning director's trying to do, and understanding that their viewpoint is taken in the extreme, but we don't have that level of control over other garden department mobile home properties. Why is this poor property, because of the fact that it's in office research for reasons that I'm not entirely sure why, and that's something I think that we probably need to go back and take a look at, why is it being unfairly penalized when every other similar property that has that is in the garden department mobile home would not be subject to it? My thoughts.
Mr. Mattson.
Yeah, I guess that's actually interesting is, and it was actually briefly related back to a comment the chair made, is I guess what my thinking is evolving a little bit is a non-conforming structure is something that is like within the setback. And because this is a mobile home park, I mean, the setback thing is a little bit different, but it's not that the mobile home is, this mobile home is within a side yard setback or something that's a non-conforming structure. It's a non-conforming structure just because it happens to have, for mobile homes, the structure and the use are one and the same thing. I guess I thought I had a moment of clarity, but now I'm confusing myself. But yeah, I guess that's.
I don't know if it's the hour or what.
Yeah.
This is. Do you want to try?
I think I'm looking at this very simplistically. So my take on this is that almost every single one of the applications that we get before us trigger 10.321, that they may not be extended, reconstructed, enlarged unless such extension and reconstruction enlargement conforms to all the regulations of the district or the ordinance. That is in almost every single application we get. I recognize that this manufactured housing park is unfairly, or not unfairly, but it is situated in the office research district. It is non-conforming. Anything that happens to it has to come to us for a variance because it is not in a district that permits it. I look at this very, very simplistically. So
I find that a very compelling argument. Thank you. Mr. Rayam.
Yeah, I still find it an overly simplistic argument, and I think that ultimately we are going to, create a lot more work for this board, which is relatively inconsequential compared to the imposition that we are going to put on homeowners in this city who happen to be in an area that their zoning doesn't match what they're doing. And there's a lot of examples of it that we've seen over the years. And someone, I mean, maybe this applicant or somebody will take this to court, and I don't see how that fundamental unfairness will survive through a court challenge. I think that fundamentally we have got to separate those two concepts, because mushing them together is creating a fundamental unfairness to property owners around our city.
I guess I don't understand that, but I'm not sure I need to understand the what's going to happen down the road. But what you're describing is how it works now.
I disagree, Madam Chair. I would argue that when we say that 10.321 is being invoked, it's always a dimensional issue associated with, I have a building of a certain size and I want to expand that in a way that is non-conforming to the dimensional requirements for the ordinance. and separate that from the use requirements for the ordinance, which says, I want to convert my building from a single-family dwelling to a two-family dwelling in a single residence neighborhood. That's a use change. And fundamentally, those are two separate concepts. And to say that, again, I go back to the example of, I own a duplex in a single residence neighborhood. It's been there forever and ever, was there long before zoning came along. I have a use that I am not changing in any way, shape, or manner. Why is my dimensional standards now being treated completely differently than those of other properties?
I think, not to get into a back and forth, but I see this, we've had a lot of applications for the Waterfront Business District, whereby we have single homes there. And, reality is they're supposed to not be expanded or anything unless they become a waterfront business, because those single-family homes are in the waterfront business. So I see this application as being very similar to that. And I don't see the use and the dimensional requirements that differently, I would say, based on, case law and whatnot. So, but no, I'm not going to make a motion.
Somebody let you,
Mr.
Mattson.
I don't mean to belabor this, but if I interpret our ordinance correctly, a structure within the waterfront, a single-family home within the waterfront business that's within the setbacks can be modified without a variance.
No, it has to come to us.
That's the argument that's being made here.
Yeah.
It has to come to us.
Yeah.
You cannot do anything to that because, oopsie, you found yourself, even though you predated the zoning, you find yourself now in this zoning that is, in my mind, by doing that, an illegal taking, by saying, I'm going to impose a zoning on you
for changing the stairs,
that says that you are going to be treated differently than everybody else.
Okay.
I think they're being treated like everybody else, but we can discuss that another time.
I think the discussion gets very messy when we're trying to generalize across all possible hypothetical scenarios. And I really think we should constrain our decision-making here to apply to this particular situation.
Would you like to help us do that?
I would like to try.
Okay, thank you.
Yes, I would like to move that. I was trying to figure out what the motion would be. I'd like to make a motion that the applicant or appellant, is it an applicant or an appellant?
An appellant.
The appellant is correct in his position that the planning department does not need to bring before the board this particular, this type of change within this mobile home park.
Is there a second?
I'll have to reword it better, but
grant the appeal.
Yeah.
Yeah, grant the appeal, right.
So it's just, approve the appeal,
I'm sorry.
grant
This
the
is-
appeal.
Yeah, sorry, I should have said it more simply. I move to grant the appeal.
Is there a second? You can't. Yeah.
Second.
No second?
Jody.
Jody.
Oh, sorry, I didn't know that. I didn't hear. Sorry. Thank you, Jody.
Okay, the basis of my motion is rooted really in practicality. This particular mobile home park has, as you will, a grandfathered use for being a mobile home park. Within the park, there are mobile homes, and as long as any replacement homes comply with 10.816, they are complying with the same requirements that other mobile homes would need to comply with in other mobile home parks. So out of a matter of practicality and fairness, I think that the appellant is correct.
Do you have anything to add?
I do not.
Is there any further discussion? Okay, so a yes vote is in favor of the appeal. Yes? Okay. I'll start here. Mr. Mattson?
Yes.
Mr. Rossi?
Yes.
Mr. Rayum?
Yes.
Ms. Record?
Yes.
Mr. Mantle?
Yes.
Ms. Margison?
No.
And I'm going to vote no as well. It is granted.
Thank you for your time.
Thank you. Thank you for waiting. You may have been able to do this in half the time if it were 2 hours ago. All right, so,
Motion to adjourn?
thank you. Second?
Second.
All in favor?
Aye.
We're adjourned.
Waiting for me to make the motion.